rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Haradinaj.
And Mr. Halling, please tell us about who's with you today.
Certainly, Your Honor. Appearing for the SPO, Prosecutor Valeria Bolici, Associate Prosecutor James Potch, Case and Evidence Manager Lena Peterson, Legal Intern Helena Kruger, and I'm Prosecutor Matt Holland.
Thank you. Mr. Rees.
Your Honor, the only change today is that Mr. Dashi is not here to assist me.
Thank you. Mr. Cadman.
The only change, as of yesterday afternoon, Mr. Solomon is not with us.
And Mr. Gucati and Mr. Haradinaj are both present in the courtroom, and we're ready to begin. Yesterday, we finalized the closing statements of the defense, and today we will hear the SPO response and any defense replies. We will then move to sentencing submissions. We expect the schedule to move along, and even if a particular section is finalized earlier than planned, of course, if you have good reason to need more time, let us know. I also invite the parties to incorporate their responses and replies into their responses and replies any further submissions to the questions the panel asked so far, if they wish to address any of those questions or the answers of the opposing party. Before I give the floor to the SPO, just to let you all know that the panel rendered a decision yesterday evening on the proposed additional evidence on sentencing. The panel admitted all the statements in full except that of Mr. Walker, which was admitted only in part. You will find the reasoning and the findings in the decision, which was notified this morning. In light of this decision, the parties may rely on these statements in their sentencing submissions. The panel asks, however, the parties to refrain from unnecessarily repeating the contents of these statements, as we have all read them and they are all now in evidence. Now we will hear the responses of the SPO to the defense closing statements. According to our schedule, the SPO has one session to do so, but Mr. Halling indicated yesterday it would take up to 45 minutes, and the panel may then have some questions to ask. Mr. Halling, you have the floor.
Thank you, Your Honor. And yes, indeed, we do intend to finish well within the time, 30 to 45 minutes. I'm going to try even to be on the low end of that estimate. And the reason why is because the arguments that you've heard in the closing statements the last 2 days have all been addressed and discussed at length, both in the final briefs and even before. Whatever else that we could say to the new information provided, our responses are predictable. Cross-cutting, contextual interpretations of statutory provisions are a cornerstone of statutory interpretation. And the Gucati defense's lack of willingness to compare Article 387 and 388 of the Kosovo Criminal Code is interesting, given its heavy reliance on these same kinds of arguments in its brief, including comparisons between Article 387 and 386 of the Kosovo Criminal Code. The MI et al. Case cited in the closing statements is a case about obstruction based on the 2003 Provisional Criminal Code, which had an element of force in the threat of force that has since been amended out of the obstruction counts currently charged, and the authority is therefore not meaningful for the proposition cited. Article 62 of the law is not the only statutory basis for classifying documents. Paragraph 37 of the confirmation decision alone provides 14 different statutory provisions as to why the SPO and or the KSC can lawfully protect information. Article 21 of the Kosovo Criminal Code talks about direct and eventual intent applying to the crimes. all crimes, and it applies to the remainder of a crime's elements, even when a specific intent is specified. This is why our answer to Judge Gaynor's hypothetical, posed at page 3744 of yesterday's transcript, is yes, that is retaliation, and the evidence in the case conforms to that hypothetical. But this is all in the direction of a cross-cutting response. We've done a cross-cutting response on Monday. What I would really like to do today is just to focus on a few key points of emphasis. And as always, if there's another aspect of the case where your honors are interested in our position, just please let me know in any questions that you have. The specialist prosecutor and Mr. Potts are going to be addressing you later today on an appropriate sentence in this case. Barring any questions, this is the last time the SPO gets to address the court on the merits of the case of the prosecutor versus Hisni Gucati and Nasim Haradinaj. The defense closing statements in full clarity. They want to resolve something other than this case. The case of the accused versus Halil Berisha. The case of the accused versus whoever leaked the batches. The case of the SPO versus uncharged people who may or may not be in an Interpol red notice. Talking about the SPO's impartiality, what foreign intelligence could have been involved, fair trial procedures, how matters within and beyond the case were investigated, thing after thing, on and on, other than what the accused did. But the evidence is admitted. This is closing statements. This is the time to discuss what the accused did and did not do. And addressing the last arguments your honors have heard from the defense requires a return to focus on this case. The core of the defense's arguments is actually premised on just a single strand. If you cut it, it falls away and the incriminating evidence is all that remains. They didn't name names. The closing statements are replete with references that they didn't name names, saying that Mr. Gucati and Mr. Haradinaj never threatened anybody or wanted to threaten anybody is contingent on them not naming names. Because they know what happens when names are named. If protected witnesses would be named, they could have felt scared. They could have been scared to death. It could cause their death. Things could happen. It would be intimidation. If they were named, they would be harmed. And qualifying it with harmed in a way doesn't show any less clarity in awareness of what would happen. And evidence for all of those propositions can be found at paragraphs 208 to 213 of our final brief. The very mantra itself, we didn't name names, that repeated invocation shows that the accused know that the names are protected and that it's wrong to name them. The accused castigations of the SPO being unable to protect its witnesses again show full awareness of what happens when names are named. We disagree with the Haradinaj defense when they said yesterday in response to Judge Matro's question at pages 3736 to 3737 of the transcript, when it said that its words about the SPO creating an unsecure environment were clumsy. The words aren't clumsy. The Haradinaj defense said what their client says. You can compare the paragraph of the Haradinaj defense final brief discussed yesterday to something like Haradinaj's written statement, where at 2D1 ET, paragraph 101, Haradinaj says, the SPO did not even protect the witnesses who they promised protection. He is channeling his client. On the accused's own admissions, the crimes fall like ripe fruit if names become public. And this is bolstered further by evidence across the case. Zdenka Pumper's evidence, Miro Jukic's evidence, the climate of intimidation, Robert Reed's comments about the effect of the mandate, all down the line. But the core contradiction of the defense's arguments presented to you throughout the trial and in these closing statements. They made names public. They made names public, leaving unredacted, protected documents for whatever public person journalists happen to show up is providing names to the public. They threw their names into the world. That names were named inevitably follows from that. This isn't about vocalizing names. It's about communicating names. And some of the names were unambiguously vocalized. It's the resolution of this core contradiction in the defense's arguments to your honors that transforms their words into threats, their criticism into obstruction, and their concessions about what happens when names are named into confessions about what happens when they made names public. Consider the constituent parts of the serious threats charged while remembering that they made names public. This is a part of the case which is addressed in the presiding judge's questions on Monday. And to recall at the outset of this that the serious threats are a joint effort of the accused and the associates. The Gucati defense attacked the specificity of what Mr. Gucati actually didn't disavow in Haradinaj's statements at page 3535 of the transcript in the closing. But to be clear, what Mr. Gucati actually said at paragraph 2376 is that he didn't think he heard one single thing he disavowed, noting that at the moment of the trial that he said that, every single statement of Mr. Haradinaj that was admitted into evidence during the SPO's case had been disclosed to him. So what do? They're disseminating confidential information. But they're disseminating confidential information and making names public. They're stating that identities of all those who cooperated with the SITF and SBO would be publicly known in the course of making the names public. The accused public assertions that they had recognized several of the names contained in the documents said while making the names public that no one would be unknown in the course of making names public, accusing witnesses of being bloodsuckers while making their names public, of being spies while making their names public, of being liars, criminals, poor morons, fools, and traitors in conjunction with a course of conduct where they made names public. Those are threats. Those are serious threats, especially considering the climate of intimidation in which they were said. And they also called them collaborators. Mr. Reese's interesting discussion of linguistics aside, Mr. Haradinaj said that calling someone a collaborator is the ultimate accusation that you can give. And any non-pejorative interpretation makes no sense. I can give your honors an example. One of the instances where the word collaborator is used in our evidence is at page 5 of P37ET. I will read the quote into the record, but I'm going to deliberately change one word. I'm going to change the word collaborator to cooperator. And we can see what impact it has on the meaning of the sentence. This is Mr. Haradinaj. On the other hand, everyone who has been against the KLA, every cooperator, every quisling, every traitor, every spy, and every family member of a spy is in favor of this tribunal, in favor of this kind of tribunal. We have declared publicly. The meaning doesn't change. There was a lot of discussion in the closing statements about a lack of intent. There's an alternative inference, according to the defense, but that is all still dependent on this core contradiction. The things that they believe from before the charge time frame and through it, all the way up until their testimony before your honors, and today, these things that they have said and these things that they've believed inform their mental state while making names public. They made their intent to obstruct the work of the court crystal clear while making names public, to show that the job done is zero, to think twice about confirming indictments while making names public, that the SPO has lied to witnesses about protecting their secrets while making names public, saying that the KSC will collapse because witnesses know now that others know who they are. And there are other examples like this. We can direct your honors to footnotes 538 and 539 of our brief. The actions aimed at undermining the SPO, which they considered to be a racist and biased court that they don't recognize, those actions in conjunction with making witnesses' names public. To say that the SPO is justice picked up from Milosevic's apparatus, will obstruct it all its life, will be an opponent for forever. This is a mental state that was operating in the charged time frame in which they were making names public. The repetition of what they do is critical to understanding them. If you take criminal action in the awareness that prohibited consequences can occur and accede to that occurrence, you're guilty of committing a crime with eventual intent under the Kosovo Criminal Code. But then you do it a second time, and then you do it a third time, and then you vow repeatedly to do it again in the face of judicial orders and a KSC prosecution and potential sentences of somewhere between 500 and 300 years, according to them. A higher degree of intention becomes clear. It becomes what you want. Ultimately, you must be considered as desiring to commit those acts you commit over and over again, with awareness of what will happen when you do. And that awareness would be to any reasonable level of certainty, noting, of course, that there is no specified statutory threshold. What I've just described is direct intent under the Kosovo Criminal Code. It's defined as when he or she is aware of his or her act and desires its commission. The evidence that we have been discussing goes straight to the elements of the offenses. It is built predominantly on evidence for which no inferences are required. If you believe those videos and what is said in them, this conduct can be legally characterized as charged and found beyond reasonable doubt. It is direct evidence. And the circumstantial evidence relied upon supports that direct evidence in all aspects and points to one and only one reasonable conclusion. because the totality of the evidence does show that the accused seriously threatened witnesses, and that they did so with direct intent. And these are key pillars in fulfilling the elements of the crimes charged. The accused resolve any reasonable doubt for you. They tell us what will happen if names are named. The core contradiction also informs the closing statement's discussion on mistake of law. We learned from the Gucati defense in their closing statement that the legal advice which prompted the citation to the second press conference is legal advice that Mr. Gucati received while on television. The Gucati defense said that Mr. Gucati's testimony was inconsistent, but it's actually reconcilable. He considers it to be legal advice, what he received on television, and then that explains why at T2392 he's able to say that, and also that Mr. Gashi was not appointed until after the second press conference. So the non-televised legal portion of the advice doesn't start until 17 September. And it's interesting to note that the accused were told multiple times in televised and video appearances that what they were doing wasn't legal. They only seemed to have heard the lawyer's advice telling them they could. Incidentally, the instances of accusations of illegality put directly to the accused are collected in footnote 541 of our final brief. But that's not even the most critical part. The most critical part on the mistake of law defense again goes back to the accused awareness that naming names was wrong. They made names public. So they knew what they did was against the law. Once your honors conclude that they made names public, which is a fact, and I emphasize that because there is no mistake of fact alleged in the final briefs, there's no more legal ambiguity. As to serious consequences, the Gucati defense, in their closing statement, significantly mischaracterized the trial panel's evidentiary rulings on the consequences suffered by witnesses. At pages 3603 to 3604 of the transcript, Mr. Reese said, "To the extent that the SPO were permitted to adduce any evidence of complaint from an anonymous third party," and then it continues in a couple lines later, "to the extent they were permitted to adduce any such evidence, that evidence was not admitted as truth of its contents." That's true only for contact notes. That's true only for the contact notes. And the rulings of Your Honor on this are decision F00334, paragraphs 93 to 94, which is the bar table decision, and the further discussion of contact notes in the courtroom on pages 1743 to 44 of the transcript. The contact notes in the case were admitted for a limited purpose. But Miro Jukic's testimony of what witnesses told him is admissible for the truth of its contents. And the same is true, incidentally, for Ms. Pumper's contact with the witness that she describes at page 1012 of the transcript. That is admissible, reliable evidence of state of mind. Even in a courtroom like in the United States, which has strict rules against hearsay, it would have still been admissible as state of mind. The contact notes have nothing to do with the admissibility of that testimony. To put it another way, if the contact notes had never existed, would the testimony have been admissible? In our submission, it would. Admissible hearsay has been accepted throughout the trial and is perfectly in conformity with the legal framework to do so. So we're not talking about contact notes anymore. They're dating, they're recording, so on. The issue on serious consequences now is the testimony of the trial. What we're talking about now is the stories. The stories heard and discussed in Mr. Jukic's testimony and compiled at paragraph 205 of our final brief. What are the stories? Well, it's a story of someone who does not feel secure at all, and that anything could happen to him. A story of someone who was in panic and was scared to go to work. Someone with panic attacks so severe that he ended up in a hospital caused by the stress of the documents leaking to the media. Someone who was very upset and angry, who wanted he and his family to relocate out of Kosovo immediately, who said he could be killed and would not cooperate unless the SPO relocated his family. The story of someone who felt his family was in danger, who tried to take steps to ensure his family's safety because people did not seem to differentiate between witnesses and spies. You have been told not to believe Mr. Jukic when he reported a witness saying, "I know very well what happened to the witnesses in Kosovo." What's not to believe? The statement and these stories of witnesses show just how scared to death protected people get when they know or think they know their name has been made public. They are the things that can happen. There is no reason not to believe you, not to believe these people, not to believe Mr. Jukic. It's the very things that could happen that the accused told us about. Mr. Rees, in his closing statement, talked about these people as person A, person B, C, D, and so on. And it's obvious why he did so. Mr. Rees doesn't know the names of the people. They weren't provided by virtue of a non-disclosure decision of the pretrial judge. And even if they did know the names, they wouldn't be able to say them in the public courtroom. But they do have names. These are real people with real families, people who couldn't have their names disclosed because disclosing their identities to these men would pose an unmanageable level of risk. But their stories are still before you, and we ask you to consider them. There was discussion in the closing statements, and I point to page 36, 26 in particular, about the climate of intimidation being 15 years old, some sort of historical relic. Where is the modern climate of witness intimidation in the evidence? Look around. This is it. This is what it looks like. This is the modern climate of witness intimidation in Kosovo. This is what the evidence in this case is showing. And these accused are people who have stated an intention to lead that climate. They will threaten, they will retaliate, they will make names public. The defense wants to make this case about all of those other cases because those cases are complicated. They have elements of vagueness and uncertainty, different answers. This case only has one answer. Thank you.
There are no questions from the panel. That being the case, we will continue on to the defense reply. Mr. Reese.
Your Honour, we, of course, have made full submissions at some length now, both orally and in writing. And I'm very conscious that under Rule 135, Sub-Rule 4, the right that I have at this stage is not to respond, but only to comment on the response that we've just heard from the Specialist Prosecutor. So I won't repeat submissions I've already made, nor will I address the challenges that Mr. Halling says the SPO have laid down, and we've already responded to. And as Mr. Halling says, the SPO has made their position clear also. We reached the stage where we ask the trial panel now to resolve the disputes that lie between the Specialist Prosecutor and the defence, and which, as Mr. Halling says, have been litigated now at some length and some degree of detail. Commenting on the response then, the Specialist Prosecutor, again, we submit, rolls up, summarises, dresses up the evidence with zealous, rhetorical flourish, referring this morning as another example to falling like ripe fruit. Well, we asked the trial panel to look at the evidence itself, to carry out a sober and detailed analysis of the admissible evidence. Mr. Halling says that there was a mistake made about the reliance or otherwise placed on the SPO of anonymous third-party complaint, the SPO claiming to rely now on the truth of the contents of those stories. Well, that was a mistake that was addressed, Your Honour may recall, when Judge Smith asked me not to make a habit of being right about something, and acknowledged that I was right, that of course those accounts were not to be admitted to establish the truth of the matters asserted in them, recognising the fact that they were not accepted, they are not accepted as true accounts, and the defence have had no ability to cross-examine the persons making those complaints. They have not been called. The SPO has chosen not to call them if they exist. So we ask the panel to set aside those passionate pleas that are made with rhetorical flourishes and look impassionately and objectively at the admissible evidence. We make the same request in relation to the analysis of the indictment and the charges set out therein. The Specialist Prosecutor has, throughout the trial, taken an approach to the interpretation of the relevant articles in the Kosovo Criminal Code, which is the widest possible approach, the widest possible interpretation, with 6 counts and every possible mode of liability relied upon for each of those counts, exhorting the trial panel to leave open as many possible options to the SPO as they can properly seek. And obviously, we have made submissions in which we reject that position, and we've set out why we say that, in fact, the true scope of those articles is much much more narrowly defined than the SPO would have the trial panel rule. And we've set out those submissions, both orally and in writing in detail, and we did so at an earlier stage in the trial, and we did so at the end of the prosecution case. And we've done so again, and we ask now for the trial panel to resolve those matters. But I make this point in response, in comment to the response from Mr. Halling, that actually a lot of that is academic in the sense that now finally, the Specialist Prosecutor appears to nail his colours to the mast, if you will forgive me one rhetorical flourish. Because really their case is one of direct intent. And we say, and we've said in relation to the counts on the indictment, where there is a specific intent, where there is, we say that it should be direct intent only, and you should set aside any suggestions from the SPO that alternative lesser intent suffice. And indeed it is their case that the defendants, Mr. Gucati, who I represent, acted with direct intent. And I urge the trial panel to take this approach, to hold the SPO to their case. That's consistent, we say, with our submissions on the law, that in fact it is, certainly for the intimidation count, the retaliation count, they are direct intent only counts. And it is the SPO's case. And they set out to prove their case. They bring these charges. They set out the case that they wish to prove and say they've proved. And if they have proved that beyond reasonable doubt, then verdict of guilt will follow. And if they haven't proved their case beyond reasonable doubt, then the trial panel should acquit. So I urge, both from the analysis of the law that we've set out, and indeed, as a matter of fairness, with the SPO finally saying our case actually is direct intent, that you should measure their case, you should test their case on that basis. And if they have not proved beyond reasonable doubt direct intent, you should acquit. I won't repeat myself further or repeat submissions that we've made before. I will simply remind the trial panel, if I may, just of the following observations that I did make. The success or failure of a criminal trial, this criminal trial, is not to be measured by whether it returns guilty or not guilty verdicts. It's on its capacity to be fair to the accused, to afford respect and dignity to all participants and the arguments advanced, its ability to judge the evidence, whether called on behalf of the prosecution or the defence by the same fair standards, and whether it delivers fair, independent, impartial verdicts based only on the evidence, setting aside emotion and passion, and an objective analysis of the law. And on behalf of Mr. Gucati, I ask the trial panel returns fair, true and just verdicts based on that dispassionate analysis of the evidence and the law. And for the reasons we've set out, both orally and in writing, we say those should be verdicts of acquittal. Unless I can assist with any further questions, Your Honours.
All right. Thank you, Mr. Rees. Mr. Cadman.
Thank you, Your Honour. As with Mr. Rees, I'm not going to make what would amount to another closing speech. We've heard from Mr. Halling once again with another passionate speech, setting their case high as one would expect. Certainly, Your Honours will be mindful of what we said yesterday, that it is the prosecution that brings this case, and it is the prosecution that must prove its case beyond reasonable doubt. And as we had said yesterday, We expect and we know that Your Honours will look at the evidence in its entirety and fairly and justly. This case is not about rhetoric and big picture. It is about detail and careful analysis. We've heard again from the SBO as to why certain statements prove elements of the offence and intent. We maintain that they do not, and that there is nothing to see when matters are looked at closely. The analysis of the trial panel needs to be careful and critical. Making names public, spies, collaborators. We've been through this before. We've heard from Mr. Haradinaj. I can refer you once again to the transcript, 2811 lines 10 to 20, where Mr. Haradinaj explains in detail as to what he means, and what he means when he refers to those that form the Milosevic genocidal regime. Paragraph 179 of its final trial brief, when the full context is read, you'll see the discussion arises in the context of a discussion on whether the SBO was falling into disrepute. And the quote relates to collapse for lack of evidence. Paragraph 210 and footnote 621, it does not show his own personal views, as the SBO allege, nor does it show any intent, as this is, in any event, from an unsworn statement. A statement that was not in evidence. Overall, Mr. Halling tried to bring this back to the climate of fear and almost an attempt to get a job done. The whole point of this case is that we say it has been disclosure in the public interest, well motivated, and proper action to prevent injustice. We maintain that the public interest works. You'll recall that yesterday I said, and I'll repeat it again today, that as counsel, it's my job in my client's interest to get at the truth. But it is also his determined objective that we should get at the truth about the stench of rot that he sees coming from the SBO. There is something rotten, but unlike Hamlet, it is neither theoretical, theatrical, or taken place in Denmark. It is much closer to home. That's why Mr. Haradinaj took the steps that he took in the first place, to expose what he considered to have been a penetration. He is a whistleblower, but in doing its job of uncovering the truth of this case, we ask that the court, the trial panel, should be guided by public interest in the broadest sense. Whilst the prosecution seeks to hide the truth about this penetration, it is the job of the defence and ultimately the court in its judgment to blow the whistle. This case has been marred by what we haven't seen and what we cannot question. We have been prevented from naming in court publicly names of those who my client believes were involved in the commission of crimes in Kosovo, in the numerous massacres that we've heard. We've not seen the documents. And we said yesterday that a central part of this case is the wholly inadequate chain of custody for which Mr. Halling and the rest of the SBO have provided no adequate response. Again, Your Honours, where there is doubt, where there are statements that are unsupported by the evidence, it is your duty to accept or reject them, whether they're presented by the prosecution or the defence. There is a grave responsibility on Your Honours in this case, as I said at the outset of my closing yesterday. This is the first case in which judgment will be reached before this specialist chambers. That is a grave responsibility for the people of Kosovo. I only ask that you review the evidence dispassionately, fairly, justly, and return a verdict of acquittal to each and every one of the counts. Nothing further that I could say has not already been said in the written or oral submissions, so I will merely stop there. Thank you again, Your Honours.
Thank you, Mr. Cadman. Any questions? It appears we will be ready for SPO submissions, and I think you wanted a break to go get Mr. Smith. So we'll take a 10-minute break and pick up at that point and start with the SPO submissions on sentencing.
All rise. rise.
Please be seated. A few inquiries since we've been moving along fairly quickly. Can you give us an estimate, Mr. Potch, of the time to be taken in your submission, or Mr. Smith, either one?
Thank you, Your Honor. Mr. Smith will address the court first, and his submission should last around 20 to 25 minutes, after which I will be making my submissions, which I estimate to be in the region of 45 minutes. In terms of scheduling, if we were to perhaps break after Mr. Smith at 11, I could resume mine after, or as Your Honor prefers.
Yeah, I'm thinking of the translators. That might be a bit much. So we will probably go up to 11, and then, unless we finish with Mr. Smith, and then we'll break, and then you can come back and do your submission immediately afterwards. And the other thing is, we would then move to your submissions on sentencing. And I guess the most important question is, how long will that take? And whether or not your clients would be ready to make their final statement today as well.
I think I can make my submissions in approximately 20 minutes. Mr. Gucati would be ready to make his statement today as well.
Good. Mr. Cadman.
I would estimate around the same, 15, 20 minutes on submissions, and Mr. Haradinaj is ready to make his statement.
Excellent. All right. We'll proceed
Your Honor,
into those terms.
Your Honor, just one matter.
Yes.
We haven't filed yet the statement of means of Mr. Haradinaj. That is ready to be served. I appreciate that is late, but we can serve it during the break.
Mr. Smith, you have the floor.
Thank you, Your Honor. Good morning, counsel. As specialist prosecutor, I am pleased to have the privilege of addressing you today as we conclude the first trial of this court. I'm before you today personally because my office has asked this court to impose significant sentences for the accused in this case. The recommendations we've made for sentence were not made lightly, and it was arrived at with significant deliberation. In the course of this trial, we provided you with evidence that amply justifies these sentences, and today I will employ my time with you to argue that the recommended sentence is both necessary and just. Having practiced as a lawyer for over a quarter century and having participated in litigation of literally thousands of cases, I must start by emphasizing how unique and rare the case before this court truly is. How rare is it to have a case where the accused essentially committed the crime on videotape, leaving no question about their malicious intent or their criminal purpose? How rarer still is it for not one, but both of the accused to exhibit absolutely no remorse for their actions or the consequences of their actions?
Your Honor, I do apologise for interrupting, but we are, of course, at the position where the trial panel's made no findings of fact, and whether there's been an offence committed or not remains to be determined. We say the prosecution haven't proved beyond reasonable doubt that any offence has been committed. So perhaps Mr. Smith could acknowledge that before he approaches the trial panel by making references to videotape evidence and what that amounts to. This is not the opportunity for a further prosecution speech in closing on the evidence.
You can make your responses when he is finished. This is final arguments. Go ahead, Mr. Smith.
Thank you, Your Honor. And to be clear, Your Honor, it's the prosecution's position that this case is proven well beyond any reasonable doubt for each of the accounts, and that the evidence I refer to is relevant not only to the guilt of the accused, which has been established, but now to the question before this court, which is what is the appropriate sentence in this case? As I said, these accused are unique in that they have not only exhibited no remorse, they've gone further and vowed, in as many ways as possible, to commit this crime or one like it in the future if given the opportunity. If that were not enough, it is the rarest of cases in any jurisdiction to have before you two individuals who are so fanatically committed to their criminal path that they have stated with utter clarity that it will require a significant sentence of incarceration if we are to have any hope of deterring them from their campaign to destroy this court. Perhaps the aspect of this case that makes it most unique is the object of the accused criminal scheme. It was not a particular witness or a particular case, but an entire institution of justice, this institution of justice. The accused did not seek to block the path for a crime victim, but for all crime victims under the mandate of this court. Together, these are facts unlike any I have seen in 27 years of practicing law. The aim of the accused conduct and the commitment to continue to employ criminal means to meet their goal of causing the total collapse of this court, Your Honors, these must be driving considerations in reaching the appropriate sentence in this case. A principal focus in determining the appropriate sentences must be the gravity of this crime, an assessment of the scope of what the accused sought to take away from so many victims who are looking to this court for justice. The accused didn't simply seek to undermine a criminal prosecution or a particular witness coming to court. They sought to destroy a court, an institution of justice created by the will of the Kosovo people and for the benefit of victims throughout Kosovo and beyond. That was the openly stated aim of the accused, and the repeated and defiant conduct was directed at that goal. Justice cannot prevail if witnesses do not feel safe. We know that. The accused know that. They sought to instill fear in the victims and witnesses of this court so they would stop cooperating with this court, so they would not be comfortable providing their evidence to this court with the goal of bringing down this institution. Let's make no mistake about that point. The accused acted with the intent to shut this court down. And they did so. They did so because they are vehemently opposed to any former KLA member being held to account for any crime they committed. And thus the accused will go to any length to deny justice, not to just one victim or a handful of victims, but to an entire witness population. In researching the Kosovo statutes applicable to this case, it's clear there's no precedent for a case like this in Kosovo, a sustained effort to take down an institution of justice. Similarly, a survey of other international tribunals has turned up no similarly broad, brazen, and craven attempt to deny access to justice for so many. To appreciate the aim of the accused in this case, we need only to listen to the words of Mr. Haradinaj, a man who called the witnesses of this court criminals, bloodsuckers, spies, who stated his intention was that the court will, quote, totally collapse because the witnesses too know now that others know who they are, who stated without caveat that we will be against this court as long as we live, as long as we can breathe, full stop. We will work against this court, full stop. For his part, Mr. Gucati has repeated this stance against the court in equally clear terms and has endorsed the statements of Mr. Haradinaj at every turn. Where the intent of the accused is so clear and so starkly criminal, and the scope of their ambition so broad, it puts the protection of rule of law in the hands of this court. For the rule of law to function in the real world, when confronted with conduct like the accused, coupled with the promise to commit more crimes in the future, this court must act with clarity to show that such conduct cannot and will not be tolerated. In this context, showing that such acts will not be tolerated means not just a finding of guilt and not just a condemnation of the conduct, but a significant sentence that addresses both the scope of the conduct charged and the need to deter the accused and their associates from doing this again. Mere days before their arrest, Mr. Gucati said he would not have any regrets about publishing these documents if he were in prison for 5 years. Mr. Haradinaj stated at that time he would feel proud to be arrested for his actions. when attending one of the press conferences and someone stated that publicizing these documents is prohibited by law and carries a sentence of 10 years, Mr. Haradinaj responded, "You think you will scare me with 10 years. Even if you sentence me to 300 years, I will still disclose them. I am speaking on my behalf and on the behalf of the whole Presidium. We are ready to face 300 years. We are ready to die. We are ready to die." The accused could not be more clear about the depth of their animus towards this court and the lengths they are willing to go to achieve their criminal goals. When the opportunity at trial to express remorse for their actions was given to them, the accused pointedly declined to do so. Instead, they made clear they will continue to commit crimes to harm this institution with no regard whatsoever for the pain and the suffering it will cause victims and witnesses, or the damage, the permanent damage it will do to rule of law in Kosovo. Their actions and their words have made it clear there is no limit to what they are willing to do to stop this court. In the instant case, the plan was to publish and disseminate witness identities, and to do so to terrorize those people, with the goal of causing this court to cease to function. In the instant case, nobody died, nobody lost his or her life because of the accused's conduct, but given the actions of the accused, given the climate of witness intimidation in Kosovo, the result could have been very easily and very foreseeably different. Think about all the people who could have been hurt, seriously, physically, and permanently hurt. We need to ponder that for a moment. And the fact that nobody was seriously injured or killed in this case had nothing to do with any real effort by the accused to limit or mitigate the damage they sought. They have pointedly told the world that that is not their problem. Their problem is this court. And if people have to get hurt for it to end, so be it. In the future, if the accused have another opportunity to further their goals of bringing down this court, we should be prepared for more serious consequences. More intimidation of witnesses, more retaliation against witnesses, threats, acts of physical violence. This time, the SPO was able to act quickly, and many media houses admirably refused to cooperate with the scheme. But make no mistake, the next time the outcome could be very different. Absolutely nothing in the words or action of the accused betray any red line that they would not cross if they believed it would serve their goal of silencing witnesses and ending this court. If a witness had been physically harmed or killed as a result of their conduct in this case, is there anything in the record of this case that would indicate they would have stopped, that they would have reconsidered, that they would have felt remorse? To the contrary, while such an outcome was clearly foreseeable, the evidence is the accused had no real misgivings whatsoever about the possibility of physical violence. For them, it merely would have represented collateral damage necessary to achieving their ultimate goal. We must ask ourselves if in the future, Mr. Gucati or Mr. Haradinaj, if they were to commit or incite the gravest of crimes in support of their efforts to close this institution, would we be surprised? Would we be shocked? Or would we be forced to say that we had no reason to be surprised, that they did exactly what they promised to do, that what they did was foreseeable and thus preventable? The harm they will cause in the future is foreseeable because they have told us point blank that they will do it again. Now, why is the conduct of the accused so dangerous? One of the reasons is because of the climate of witness intimidation that exists in Kosovo. The acts of the accused both seek to exploit and to contribute to this climate. They have nurtured and they have stoked it at every opportunity, as you saw during the evidence of this case. Through their crimes, they seek to take advantage of it, to light the fuse and then wait happily for the destruction that follows. The existence of this climate was made crystal clear by one of the defense-owned witnesses, Mr. Robert Reed. Based on his lengthy experience at the ICTY working on KLA cases, he said, "Witness intimidation in the trials in Kosovo. I've never seen anything like it before. I was a policeman for 20 years, and I've worked here at the ICTY for 23 years, and I've never seen intimidation like it. It was really quite frightening." When confronted with this statement, the court, I'm sure, recalls, in this courtroom, the witness stated that he did not take a word of it back. Importantly, for the purposes of sentencing, Mr. Reed also explained the exponential effect the climate has when a single witness information becomes public improperly. Quoting Mr. Reed, "A leak of any information is detrimental to a prosecution's case. The leak of a witness information is doubly detrimental in that it only impacts the potential of your case, but it also impacts the psychology of the particular witness. If it's found to be, if the witness community finds out about it, it also impacts other witnesses. So you know, if 10 other witnesses find out about it, that's a huge impact on your case. You don't just have one witness who you've got to be concerned about. If it's leaked, if it becomes public knowledge, then you've got 10 to say 15 to 20 witnesses who it impacts. Imagine now the effect when the acts of obstruction were taken not against a single witness, but against dozens and dozens of witnesses. Your Honors, the crimes of the accused affected every potential witness in Kosovo, and the accused knew that well. The accused seek to dismiss the words of their own expert by claiming he was talking about something that existed only in the past. Your Honors, that is just really a bit much when the evidence you've heard in this case tells you the accused literally spend their days doing all they can to maintain and exploit this climate. Nobody in Kosovo believes that the targeting, threatening, and intimidation of witnesses willing to provide evidence against former KLA members is a thing of the past. It is well documented, has been part of this case, and continues to this day. To be very frank, it is a climate denied only by those unfamiliar with Kosovo today or those who seek to employ it in their favor. In fact, part of the reason this court was created and why it was relocated here in The Hague was this climate of intimidation. It is a reality that it's worked in the past to prevent witnesses from coming to court and saying what they knew about KLA crimes. The accused know this history well, and they hope to use the same strategy here to intimidate witnesses because it had worked in the past. As this institution moves forward, we will need to do so recognizing the continuing reality of this climate and the fact that the accused and their criminal associates will continue to employ it at every opportunity. The question for the court today is how much opportunity will they have? Given their roles in the KLA Veterans Association and their willingness to use that organization's resources, membership, and platform to implement and further their criminal schemes, the existence of this climate expands the scope and the likelihood of harm that the accused can and will cause in the future. It makes the accused even more dangerous of individuals, given the unwavering intent they possess to destroy this court. In fashioning the appropriate sentence, this court should think not just about the two accused, but also about the message that will be sent to others. Others outside this courtroom whose conduct will undoubtedly be influenced by this court's decision. The accused are part of a small group of people in Kosovo who are personally devoted to having this court fail at any cost. While this group grows smaller by the day as our cases move forward and the truth of the crimes we've uncovered becomes public, there will always be those like the accused who cannot and will not be swayed by facts, who have a personal interest in clinging to a false narrative they have engineered and promoted for 2 decades, that no crimes were committed by anybody in the KLA. People like the accused co-conspirator, Fatan Klanaku, they are watching right now, And they're watching to see what sentence these accused will receive so they can make a determination if they want to follow in their footsteps. Like it or not, the sentences in this case will either serve as a deterrent or as an incentive to people like Mr. Klanaku. We know because the accused have told us they will not be deterred in the slightest if they receive a sentence of 5 years or less. There is no reason to believe their like-minded associates and co-conspirators would have any different view. For these reasons, we are asking not just for a finding of guilt and a finding that the accused's conduct represents a serious threat to this institution. We are not just asking for a finding that the accused lack remorse or a finding that deterrence is a valid and important consideration in this case. No, we are asking you for a sentence that will actually serve to deter. Mr. Potch will address the cases from other tribunals in his remarks later this morning. But let me just say this about those other cases. In addition to being factually distinguishable from this case, many of those decisions were, in our view, deficient. And they were deficient because they gave lip service to the need to deter. In fact, many made very clear findings about the need to deter, but then issued sentences that had no deterrent value whatsoever. Despite the fact that obstruction cases and obstruction of these institutions has been a plague on international tribunals. We are asking this court to do better. We are asking this court to learn from past tribunals and issue a sentence that actually deters. A sentence that matches findings of fact and findings of law that are inescapable in this case. Now, I've focused on deterrence to this point, both the deterrence of the accused and the deterrence of others. But let me also talk about why the sentence we are asking for, a significant sentence of 6 years incarceration, is also a just and proportionate sentence for the acts of the accused. The conduct of the accused was extraordinarily grave, dangerous, repeated, and unrepentant. They were repeatedly told to stop, and they continued. They were repeatedly warned they were violating the law and that it could have dangerous consequences for victims and witnesses, and they scoffed. Again and again, they encouraged more deliveries of secret information, and each time they got documents, they acted as quickly as they could to disseminate them, goading the press to publish them as widely as possible. Through their actions, the accused sought to intimidate and retaliate against witnesses across Kosovo. They tried to stop the work of this court in its entirety. The accused sought to cause harm, a scope of harm that's as wide as in any obstruction case in any international tribunal. And for this reason, the sentence we've requested is warranted, it is deserved, and it is just. Having said that, I recognize that handing down a significant sentence like the one we've asked for is no easy thing. And I have to imagine the court no more likes to be in the position of imposing a significant period of incarceration on another human being than I like having to be here standing before you asking for such a sentence. The reality is that imposing a sentence in a case like this represents a choice. A significant sentence represents one choice, but not giving a significant sentence also represents a choice. And each choice will send a message to those who seek to obstruct the work of this court. This court, the power of it resides in it being a safe place for witnesses to speak openly about what they suffered through, about the crimes they saw, about the crimes they saw their family members suffer through. The only way it can work as intended is if witnesses feel safe to come here, to this building, and tell their stories. If provided the opportunity, the accused will stop at nothing to prevent that very thing from happening. I pray that you give that reality the highest consideration in reaching the appropriate sentences in this case. Thank you.
Thank you, Mr. Smith. We'll take a break now for morning break. Be back at 11:30. We'll be ready to start at that time. Mr. Pachi will be up next.
All rise. All rise.
Be seated, please. All right, Mr. Patch, you have the floor.
Thank you, Your Honor. I will continue to address a number of issues relevant to sentencing. I will first focus on the manner in which the accused's conduct harmed the victims.
The interpreter's note, could the speaker kindly slow down for the purposes of the interpretation, particularly when they're reading such complex legal ideas? Thank you very much.
Yes, I will. That was early and noted. I will then turn to the issue of why it is highly relevant for sentencing purposes that the accused undertook a strategy to obstruct and intended to obstruct the entire KSC and SPO. Next, I will address the importance of adequate sentencing in contempt cases. And finally, the appropriateness of the sentence requested. Throughout, I will show why a number of matters raised by the defense in relation to sentencing should be given little or no weight. I look forward to answering any questions you may have. In the SPO's final trial brief, the accused's participation in the crimes was described as direct, systematic, persistent, deliberate, and enthusiastic. Those are a lot of adjectives, Your Honors. But for the reasons set out in the brief, and on the basis of the evidence before you, they are all accurate and all relevant to your considerations on sentence. While we're on the subject of descriptive terms, I'd like to remind you of some of the adjectives used by the accused during televised appearances to describe persons who had cooperated or are cooperating with the SPO. These words, traitors, liars, criminals, bloodsuckers, they're not merely harmful to witnesses because they constitute insults, because they might offend the witnesses. When the panel considers the context in which they were expressed and the accused's intent, it becomes clear that these words can only be described in one way, as intimidating. They were designed to expose witnesses, to marginalize them, to label them. And such labeling is dangerous, Your Honors. It seeks to have witnesses considered as less than, as enemies, as not deserving of their basic rights. And this labeling by the accused is not only an attack and a threat. It legitimizes and invites others to target, attack, and threaten witnesses, isolating them in their communities. Significantly, the accused did not pick the labels they used at random. They chose the ones they knew could lead to the ostracization of witnesses, to shaming, and to attacks on them. In the context of Kosovo, in the aftermath of the conflict there, being called a traitor or a collaborator, being described as someone who assists the Serb cause in any way, is the most dangerous and harmful thing you can be called. In a country that has been through so much, seeking to portray someone as somehow being against the national cause, against the country's heroes, is a very dangerous game. The consequences of this are entirely foreseeable. Further attacks, harassment, and intimidation. The witnesses brave enough to have cooperated with the SPO and KSC did nothing to deserve attacks by the accused. And there were many victims of the accused crimes, all of whom were particularly vulnerable or defenseless, if not both. Indeed, the evidence before you establishes that the accused disclosed the identities and personal data of hundreds of witnesses to the public. They did this in the same breath as they labeled them traitors, spies, liars, bloodsuckers. On this issue, I note that, as the specialist prosecutor mentioned earlier today, you heard one of the defense's own experts, Mr. Robert Reed, explain, in response to a question put by the panel, that it's not only any particularly mentioned witness that is impacted by actions such as those of the accused, but the witness community more broadly. Witnesses in many courts, perhaps especially one of this nature, are in an unenviable position. Most of us will be lucky enough never to know what it really feels like to be in their shoes. But try to imagine for a moment that you were. Imagine you provided information to the SPO because you wanted justice to be done. That, for good reason, your identity is protected from everyone but the SPO. Your neighbors, who believe the KLA is incapable of having committed a single crime, have no idea about your cooperation. Maybe your family doesn't know about it either. And then suddenly, names of witnesses such as yourself are being read out on television. They're being plastered across the media. You know your name is likely in those same documents being made available to anyone who wants to look at them. And you know that soon, all those people whose interests differ to yours, who do not want to seek justice, who want this court to go away, will know who you are. They may even know what you said to the SPO. Imagine the fear you would feel, that your name would be read out, that you'd be confronted. The evidence is that witnesses in this case felt those fears because of the actions of the accused. None of us would wish that on anyone. Turning to certain defense submissions. The assertion that the accused only made confidential documents available to the professional press is inaccurate and, even if true, irrelevant. The submission that Mr. Haradinaj did not publish any documents and the argument that press conferences were broadcast by professional media only are also irrelevant. In relation to these submissions, I note another of the defense's expert witnesses, this time Ms. Anna Myers, describing a person's decision to go public with information as the, quote, nuclear option or the option that is the most difficult to manage, end quote. And this is an apt analogy because nuclear weapons are devastating, irreversible, and this is particularly important, they have long-term effects. The accused's conscious decision to give these documents out during press conferences to anyone who would have them and after begging for them to be taken was what led their contents to be publicly available. This was a calculated move to use the press to maximize distribution, to maximize the damage to this court and its witnesses. The moment the accused made these items available, the consequences were indeed potentially nuclear. Once unleashed into the world, controlling them would be impossible. Additionally, the accused did not merely hand documents over to the press, they described their detail in great content at the 3 press conferences and other televised appearances. Their intent in giving the documents to the press was to ensure this broadest possible dissemination. The basis for the Gucati defense assertion that names mentioned in the press conferences were few in number is unclear. The panel is seized of evidence in which the accused themselves uttered the names of multiple witnesses. In addition, or alternatively, the accused directly uttered other identifying information. Further, the accused specifically named certain individuals while revealing that the SITF or SPO considered them persons of interest. Unfortunately, these names were not the only ones that the accused made public without authorization. The accused also uttered the names of various locations in which the SITF or SPO were focusing investigations. Locations in relation to which the SPO was trying to establish whether certain crimes had occurred, whether there were victims whose stories needed to be told, victims who deserve justice. I hope, Your Honors, that you can fully appreciate the danger of these revelations. They were harmful to witnesses since they created a real risk to the safety and security of persons who are known to have been victims at crimes at these locations. The SPO had never made any of this information on its locations of interest public. Would any prosecution office do so unnecessarily in a situation when investigation is ongoing and such revelation could jeopardize it? No. The accused's actions took the SPO's power to choose the appropriate time to reveal such information out of the SPO's hands. The accused's actions forced this information into the public sphere prematurely for all with an interest to know about. That was an irreversible, calculated step taken by the accused. In considering all this, it can't be forgotten that even when the accused were not the ones speaking the names and uttering confidential information in televised appearances, the accused are the ones who chose to make such information public by giving it to the press. For a glimpse at the harmful impact of the accused's actions, the panel may consider, for example, the fact that the names of the locations mentioned by the accused, or included in the documents they made available, were plastered across articles online for all those to see. I'm here referring, for example, to P121ET, P125ET.4, and P155. Not only do such articles list several locations, some also publish the names of the victims in relation to each such location and the relevant time periods of the alleged crimes. This is where the people who cooperated with the SPO could see their names and where they could confirm their worst fears. Considering evidence such as this, of which there is an abundance, it's easy to see how, as a direct consequence of the crimes, witnesses expressed anger, concern, and fear, and felt threatened or intimidated, with some requesting not to be contacted again, and two even having been relocated. Indeed, defense assertions that no adverse consequence for any specific investigation or prosecution has been established ignore the evidentiary record and reality. The claim that there is no evidence of threats, intimidation, or reprisals is blind to essentially the entirety of the facts and the evidence in this case. The desperation of witnesses in the wake of and due to the crimes committed by the accused is exemplified in the following exchange from Zdenka Pamper's testimony. Witnesses wanted the SPO to act as though they can no longer be traced. That's what the accused's actions led to, a desire to disappear, to be untraceable. And this desire is completely understandable given what the accused said about such persons, given the means they used to say it, television, social media, and given the knowledge that members of society in Kosovo will have about what has happened to persons who cooperated with authorities in proceedings against the KLA in the past. The fact that despite the accused's best efforts, other witnesses have remained unwavering in their commitment to justice, as have the KSC and the SPO, should in no way result in any credit to the accused. Turning to the relevance of the fact that the accused undertook a strategy to obstruct and intended to obstruct the entire KSC and SPO. The accused's conduct was no momentary lapse, no knee-jerk reaction to an allegedly unexpected event. It was a long time in the making. Their conduct built upon their previously failed efforts to stop this court, this time clearly crossing the line into the patently criminal. The accused had many options available to them on receipt of the documents at issue. They had choices. The option that they did decide on, following consultation with their peers, was undertaken with full knowledge of what it would and could lead to, of the endless amplification that including the media would result in. They could have chosen another option, but they didn't. And why would they when their goal was to undermine this court? They made their choice a recurring one, holding press conferences to maximize impact every single time, disseminating the confidential documents received every single time, appearing on television every single time, calling for more leaks every single time. And all this despite judicial and prosecutorial warnings. All this until they were arrested. This was a strategy, a campaign. The evidence leaves no doubt about this. The accused also made it crystal clear that they would continue these same actions if given the opportunity.
Mr. Potch, is it your intention to have this in the transcript? Because you'll have to read it aloud if that's your case.
There's no need for that, Your Honor. They've all been used before. I hope by now the panel is highly familiar with these key pieces of evidence.
Just a reminder, thank you.
Thank you very much. You see here Mr. Gucati stating, if we could, we would get rid of the special court in 5 minutes. We will disband the special court. These are few of many assertions by the accused manifesting the intent to obstruct the KSC and SPO as a whole. A review of exhibits P2, 4, 18, 21, 24, 25, 26, 28, 29, 35. That will show that both accused clearly indicated their intent to commit further crimes of the same nature as those charged. And that includes instances on the 9th, 11th, 16th, 17th, 20th, and 22nd September. The accused also indicated their intent to commit further crimes of the same nature to Your Honors directly during their testimony, as we'll see from the next excerpts. These video excerpts will be with English translation. The interpreters have the equivalent or corresponding Albanian, which they can use for interpretation purposes.
Haradinaj, that doesn't answer my question. I'll ask it again. So you would...
No, don't ask the question. If you bring them, I will act the same, because I am convinced that I acted rightly and I did it in the interest of informing the public and for the sake of transparency. I think that, I have that conviction, that it was appropriate.
All over again.
I said it earlier as well, yesterday and the day before. I'm not a guardian of anyone's, of this institution or the offices here in The Hague. I look after the work for which I'm paid. So please do not provoke me with questions regarding this documentation.
These factors this perseverance and determination by the accused are highly relevant to Your Honour's determination on sentence. They show the serious nature of the conduct, the objective always being to inflict the maximum possible damage to the KSC and SPO, to force these institutions to cease existence. As professional judges in a court with a mandate to try crimes, including war crimes and crimes against humanity, you act as guardians of this mandate. The crimes committed by the accused are particularly grave. They threaten everything the KSC and SPO stand for and have worked towards. They are directly opposed to the fundamental rights of the brave witnesses and victims who have cooperated with our institutions. They threaten the mandate that you guard. The fact that any court has to deal with matters of contempt is by no means novel. Issues of contempt of court have come up time and time again before several other international courts. The punishments in such cases in the past have not even remotely succeeded in deterring further obstructions. Contempt cases, as we all know, are unfortunately a recurring feature at other courts, and we have our first one here today, even before a single judgment on a charge of war crimes or crimes against humanity has been pronounced by this very court. We need to rethink how we approach obstruction cases, to treat them with the severity they deserve, reflecting the severe consequences the obstructive conduct may have on cases concerning war crimes and crimes against humanity, those cases that the obstructive conduct seeks to destroy. Holding individuals to account for obstruction cannot be seen as just a necessary evil a court such as this has to deal with. If the court is to succeed in achieving its mandate, obstruction cases must be seen as vital to the court's mission. We talk a lot at this court about the importance of victims and witnesses, and rightly so. But this cannot just be lip service. This case is about victims and witnesses, about protecting their interests. They are central figures who deserve the attacks against them to be adequately punished. As the Specialist Prosecutor said earlier, the need for deterrence is important, and it's especially acute in contempt cases. The only ingredient necessary for crimes of a similar nature to those we are dealing with today to be committed again is the will of an individual to obstruct. And the accused's actions and their words, their testimony even in this case, leave no doubt about the fact that such will is ongoing. The accused remained unremorseful even during their testimony.
Have any remorse or regret for the actions you stand trial for?
Deri mes ditën e sot.
I have never had a chance to regret in the 54 years of my life, 30 years of work and so on and so forth, where I make a mistake, I apologize. There is no need for me to apologize for anything. I did not steal these documents and take them to the WVA headquarters. If I'd done that, I would apologize for that burglary. I have not committed to any burglary. I have not offended anyone. I haven't insulted any witness or anyone else. So there is absolutely no reason for me to apologize because I have not caused harm to anyone.
Mr. Haradinaj, do you have any remorse for what you did with the documents delivered to the KLA War Veterans Association?
Për ata të cilën unë
thing that I accepted that I did, I do not feel any remorse. I accept what I've done because I think it's in the interest of transparency and public interest. So I only fulfilled an obligation that I felt I had to fulfill, and that it was taking those documents and moving them from here to there. And I don't feel remorse or regret about the words I said to the people who tried to confuse me or trick me, because I've not done anything. And I am fully convinced, I was fully convinced that it was in the public interest and for the sake of transparency. And that's why I did it. And I thought it was my duty, not only my duty as a citizen, but the duty of every citizen to promote free speech.
No regrets, no remorse. Further, the accused have already told anyone who would listen that the prospect of imprisonment would not deter them from undertaking criminal actions in the future.
If I was working in the media, you'd see that I dared or not. You'd think you'd scare me with 10 years, even if you sentenced me to 300 years, I will not discuss them.
Mund të ketë ndonjë pasojë penale për këtë, ju nuk jeni pishman themi që po I publikoni këtë.
Unë asë 1 milimetër, unë edhe 50 burë më jep, unë imi gatshëm të përgjigjen gjykatës speciale për publikimin e dosjeve.
Here we saw the accused, as always, echoing each other. And it is not merely the real risk of the accused committing, once again, the very same crimes that they have already committed, that this panel and those who support this institution should be deeply concerned about. The accused's intent, as established both during the temporal scope of the charges and during their own testimony, makes it clear they'll do whatever it takes to put a halt to this court's work. If the accused cannot get their hands on further confidential documents, they'll find some other way to obstruct the SPO and KSC. Mr. Gucati made this clear when, for example, in response to a question by the panel, he stated, "I am against this court and I remain against it." When he stated, it is his responsibility to undermine the court. And when he made no qualms about the fact that given the opportunity, he and others would disband the KSC. Similarly, Mr. Haradinaj asserted he will not follow the orders of the court or recognize it, and it was his and others' duty to work against the court. He said the KSC should pay its price, that he and others in the KLA War Veterans Association, quote, "will be against this court as long as we live, as long as we can breathe," end quote, and that, quote, "we will work against this court, full stop," end quote. Mr. Haradinaj said that unless this court somehow began to function on his terms, he would be the SPO's opponent forever. And, Your Honors, it's not just the accused who you and all those interested in the pursuit of justice should be concerned about. You've heard evidence, primarily from the accused themselves and other defense witnesses, that the KLA War Veterans Association is an organized, hierarchical organization spread out across Kosovo and counting over 10,000 members. You've also heard in evidence how the decision leading to the commission of the charged crimes in this case were not only made by the accused, but by several other high-ranking KLA War Veterans Association members. And the evidence in this case establishes that such other members or persons affiliated therewith share the same objectives as the accused when it comes to this institution. You heard Mr. Haradinaj saying as much. God willing, he will bring us more. It does not mean that it has to be only me, Mr. Gucati, Mr. Faton Klinaku, who will do it. Even the lowest ranked KLA member here will carry out that task. You also heard one such other KLA War Veterans Association member himself unashamedly express his views on the disclosure of confidential documents in this very courtroom. He remains happy to this day that statements of protected witnesses had been made public. This intent, this support for the accused crimes, coupled with other factors, such as the specific timing of the offenses and the nature and extent of the information made public, are all reasons for your honors to dismiss defense calls to consider sentences in other cases as relevant to your determination of the sentence in this case. I'm here referring to the Gucati defense assertion that Mr. Gucati will have been in detention for 18 months and that no sentence of that length has been imposed in any previous comparable domestic or international case. I'm also referring to the Haradinaj defense submission that it's important to pay regard to comparable international practice in imposing sentence.
The interpreters kindly ask the speaker to slow down when reading. Thank you very much.
Jurisprudence from other courts and tribunals makes it clear that the totality principle requires an individualized assessment of the particular circumstances. And this means that any attempt to compare an accused case with others is of limited, if any, assistance. This is because differences in, for example, the number, the type, and the gravity of the crimes committed, the personal circumstances of the convicted person, the presence of any mitigating or aggravating circumstances dictate different results in different cases. In particular, the cases cited by the Haradinaj defense in filing F00570 cannot be considered comparable to the case against the accused. The number of witnesses whose identity was disclosed in those cases cannot compare to that in this case. In Marjacic and Rebic and in Jovic, the unauthorized disclosure concerned one witness in each of those two cases. In Al-Kayat, it was 3, and in Al-Amin, it was 32. Not 50 witnesses, Your Honors, not 75, not 100, not even the 150 witnesses, which in this case is the approximate number of witnesses referred to in Batch 3 alone. The nature of the information made public was also different in those cases. None of them included unauthorized disclosure of an internal document analyzing evidence and applicable law in relation to persons of interest and identifying information in relation to a large amount of witnesses. The persons convicted in these cited cases did not assert publicly and repeatedly that they would undertake the crimes they were convicted of again. These factors more than suffice to show that Your Honors not only need not, but should not seek to compare any sentence you have in mind for the accused with those in the other cases referred to by the defense. And Your Honors, this point is even made in one of the very cases cited by the Haradinaj defense. And I'm here referring to the Al-Kayat reasons for sentencing judgment at the STL. And paragraph 22 of that judgment, the single judge states, quote, "Finally, I note that the case law of other international tribunals cited by the parties concerns cases that, quite clearly, are factually very different from this case. As a result, in determining the sentence to be imposed on Ms. Kayat in this case, I cannot be guided by the penalties imposed in those cases." End quote. Several other defense submissions on sentencing should be dismissed. Not a single submission is able to detract from the appropriateness of the sentence requested by the specialist prosecutor. And that is because the requested sentence would adequately reflect the gravity of the crimes, the accused's specific conduct, recognize the multiple aggravating factors, and hopefully serve to deter the accused and others from future commission of crimes of the same or similar nature. Many of the defense submissions focus on what the accused have not been charged with. These attempts to distract from the grave nature of the accused's crimes and conduct should be dismissed. The panel has wide discretion as to the weight to be accorded to any mitigating factor it considers. The factors raised by the defense should be given little or no weight. Even if the panel were to find that there are certain mitigating circumstances, this would not automatically entitle the accused to a credit in the determination of their sentence. Rather, it simply requires the panel to consider such mitigating circumstance in its final determination. Contrary to defense assertions, it is irrelevant that the accused may have had no involvement in obtaining from the SPO or elsewhere the documents they made available to the public. It's also relevant the accused are not charged with stealing such documents. These are extraneous considerations. The accused should be sentenced on the basis of the relevant charges and related factors, not on the basis of anything they may not have done or have not been charged with. The defense asserts the accused did not use or threaten violence, and that there's no evidence of physical harm suffered as a result of the accused's actions. We all know that violence, or the direct threat of violence, or even the inflicting of physical harm, has not been charged. That does not mean that the accused are entitled to any form of discount in sentence. Further, while the accused may not have undertaken acts of violence or even directly threatened it, they certainly incited people in the public at large to a point where such acts could have been expected. In relation to ill health, we say only that this should be considered mitigation only in exceptional or rare cases. And as to the Gucati argument that account should be taken of the detention conditions in the context of a global pandemic, this should have no influence on the sentence to be imposed. The registry has ensured full respect of the accused's rights while detained. There is no reason to doubt the registry will continue to ensure this is the case, no matter where the accused may be incarcerated upon conviction. Arguments to the contrary should be dismissed as entirely speculative. The Haradinaj defense argues that the fact that the accused has asserted he was acting in the public interest should be taken into account. Yes, they have asserted that, but no, Your Honors, that should in no way factor into your assessment. Mr. Haradinaj's actions, and Mr. Gucati's for that matter, demonstrate the contrary. The evidence shows they did not undertake their actions because of any public interest. They committed the crimes because they wanted to obstruct the work of this court, to intimidate and retaliate against witnesses. That is not in the public interest. Calling witnesses liars, spies, traitors is not in the public interest. Seeking to ensure justice will not be served is not in the public interest. Arguments of this nature, asserting that weight should be given to claims an accused's conduct was motivated by a desire to pursue the truth or any particular moral or social value, have rightly been rejected at other courts. The main reason for such rejection is that it is immaterial when one considers that the means chosen by those accused amounted to crimes. the defense submissions that the accused are allegedly of good character are of limited relevance. While good character may be an indicator of a lower risk of recidivism in some cases, it cannot be said to apply in this case. This case where the accused are resolute in their intention to commit further offenses. This is not a case where the panel only heard about the conduct of the accused through witnesses or even through the testing of the accused themselves. In this case, the vast majority of the relevant criminal actions by the accused are caught on tape. Tape which is in evidence and on which your honors are able to see the character of the accused in the relevant context, in full, uncensored, unbiased display. Any indication of good character would in no way detract from the actions the accused stand trial for. Assertions of good character, where it matters, are wholly incompatible with, for example, the accused calling witnesses liars, spies, traitors, criminals on television. Another defense submission which your honors should reject is that in which the Gucati defense argues the panel may suspend any sentence of imprisonment on the accused, relying on certain provisions of the KCC. And the reason for this is that those KCC provisions do not apply before this court. This is clear when one considers Article 3.2c and Article 3.4 of the law governing this court. Article 44.4 of the law states that the punishment imposed on persons adjudged guilty of crimes under Article 15.2, those crimes we're dealing with here today, quote, shall be in line with the punishments for those crimes, end quote, set out in the Kosovo Criminal Code. This refers to the sentencing ranges provided for in relation to crimes such as those by the accused, which ranges are contained in provisions expressly incorporated in the law. Should the panel deem, for whatever reason, that it does have the power to suspend a sentence on the accused by virtue of the 2019 KCC, then our submission is that on that code's own terms, no such suspension may be imposed in the present case. And that is because of Article 47 of the KCC, which reads as follows, quote, the purpose of a suspended sentence is to not impose a punishment for a criminal offense that is not severe when a reprimand with the threat of punishment is sufficient to prevent the perpetrator from committing a criminal offense. End quote. The evidence before you and the nature of the crimes show that this cannot be said to apply in relation to the accused. Another defense submission your honor should dismiss is the argument that a fine may be appropriate in the circumstances of this case. We addressed this in paragraphs 418 to 422 of our brief, where we provide the numerous reasons why, to the contrary, the sentences imposed should be primarily custodial. I won't repeat those submissions other than to reiterate that the panel should not set a monetary value on the commission of crimes such as those committed by the accused, especially when several persons would be willing and able to incur any such financial cost in order to obstruct the work of this institution in the future. The only appropriate sentence is a custodial one. The specialist prosecutor's requested sentence is fully warranted, proportionate, and necessary in this case. To conclude, we, as institutions, we ask a lot of our witnesses. We ask them to hearken back to the darkest times of their lives and tell us in detail what happened, how it made them feel, who they lost, how and why. We ask them to leave their familiar surroundings, put their lives on hold, and appear in a courtroom where every assertion will be analyzed and often questioned and dissected. We ask them to wait patiently while the justice they have been looking forward to for several years is served. We cannot ask more of them. We cannot ask them to ignore threats to their lives, to ignore threats to the lives of their loved ones. We cannot ask them to tolerate public calls intended to intimidate them, to turn a blind eye to the fact that two men with thousands of followers are sending them a message to be silent. Your honors have the power to make sure that more than what is absolutely necessary to see justice through is not asked of these witnesses. And your honors, you can do that by imposing the sentence requested by the SPO, which sentence is fully warranted in the specific circumstances of this case. Thank you.
Any question? Any questions, Judge Barton? Judge Mitro has a question for you, Mr. Butch.
Thank you, Judge Smith. Mr. Patch, I have one question for you, and it's a question that goes to a rare point of convergence between you and the defense, so I can't afford to miss that chance. In your written and now oral submissions, you've made reference to a number of cases from international or internationalized tribunals, the ICTY, the ICC, and others, both in relation to the test of cumulative conviction and in relation to the factors of relevance to sentencing. Now, what I want to ask you is the basis on which you say this panel would be permitted to apply these authorities or precedents in this particular jurisdiction. Are you saying there's a direct legal basis that enables us to do so? Are you saying they reflect general principles of sentencing or cumulative conviction? Or are you saying that this is a non-binding guidance that would be relevant perhaps to our discretion? I'd be grateful, and I will ask the same question of Mr. Rees when I get a chance.
Thank you, Your Honor. With certainty, it's the latter of the options Your Honor enunciated, which is by way of non-binding guidance. To be clear, the convergence is limited between ourselves and the defense. We agree you can consider jurisprudence in relation to general principles, but for the reasons I touched upon in my oral and in our written submissions, when it comes to comparing the sentences imposed, that is not going to be of any guidance to Your Honors.
Well, at least you converged on a point of law, Mr. Patch, but I am grateful.
Judge Gaynor, anything? All right, we will now move to the defense submissions on sentencing. The panel asks the defense, as for all such comments, not to repeat unnecessarily any submissions made in the final trial brief, or in Mr. Cadman's case, not in filing F-570. Mr. Rees, floor is yours.
Quite right, Your Honour. I will not repeat the submissions we've made at length as to why we say there was no threat, submissions as to intent, submissions as to serious threat, submissions as to harm and consequences. We've made those submissions. And in doing so, we responded to the highly selective approach of the SPO, picking out and isolating remarks from Mr. Gucati and inviting Your Honours to look at them in isolation. And we did that by taking, Your Honours, we hope, through some of the evidence, simply to place that selective approach into some context. And I repeat that what I urged previously, and I know the trial panel will, look at all the evidence in the round, in totality, in its context, and make the findings that are required by the indictment. It is your view of the evidence that counts, and your view alone, not that of the specialist prosecutor. And I repeat the request that I made previously, both in writing and orally, that the approach that should be taken at this stage is for the trial panel to retire, to deliberate on the counts, reach judgment, and then allow us to make submissions on your findings of the evidence your findings as to issues of threat, intent, harm, consequences, rather than on the SPO's view. And I do repeat that, given that this is a case not involving a single count, or indeed even a straightforward case, a case involving 6 counts, with multiple different factual outcomes that Your Honour could arrive to. That is our request, but I will continue, nevertheless, to do what I can to assist in the circumstances in the absence of those factual findings. As I say, I won't repeat what I've said on Tuesday or Wednesday, nor will I discuss or treat Your Honours to my own personal experience. We did hear much from the Specialist Prosecutor about his personal experience, referring to his 30 years. It is difficult to understand where Mr. Smith has spent those 30 years, if he is yet in 2022 to come across video-recorded evidence of the commission of offences. No CCTV of violence taking place, unlawful violence, whether on the street or indeed in the form of the repression of peaceful demonstrations by state authorities. No smartphone recordings of sexual violence and torture, whether in the home or whether state-sponsored. No press footage of police officers using excessive force, or of the shooting of civilians during wartime by state forces. Perhaps he has spent it in such rarefied and isolated air that he has no actual experience in his 30 years of common everyday life and common sense. I said at the outset of our closing statement that the Specialist Prosecutor had showed a lack of respect for this court, daring the court not to fail it by refusing what was requested by the Specialist Prosecutor. And we can add to that lack of respect, sadly, a lack of respect for every other international tribunal and court that sits in this city, that Mr. Smith has demonstrated, clearly stated on camera. However lightly or otherwise the Specialist Prosecutor made his decision about the appropriate length of sentence, it is not his decision to make. It is yours, and it is yours alone. Articles 69 and 70 of the Kosovo Criminal Code set out helpfully a list of what they describe as general rules on calculating punishments, and indeed a series of factors in Article 69.3, and then general rules on mitigation or aggravation of punishment under Article 70. And again, a list helpfully, not exclusively, but setting out a clear list of aggravating circumstances and mitigating circumstances. And I will do my best in the circumstances, in the absence of your factual findings on the case, to assist as best I can with those. Article 69 refers to the degree of criminal liability. Obviously, the greater the degree of criminal liability, the more serious the culpability in the sentence, the lesser the degree of criminal liability, the lesser the appropriate sentence. Article 69 refers to the motives for committing the act. It refers to the intensity of danger or injury to a protected value. It refers to the past conduct of the perpetrator. Article 70 refers to the degree of participation, the degree of intention, the presence of actual or threatened violence, whether an offence involved multiple victims, whether there was an abuse of power or official capacity, any relevant prior convictions, circumstances falling short of grounds of exclusion of criminal responsibility. The personal circumstances and character of a convicted person are obviously relevant, whether liability is as a principal or through accessorial liability, one being more serious than the other. And it also refers to cooperation general cooperation with the trial court itself. Firstly, the court has observed Mr. Gucati and his cooperation with the court, both during the course of court proceedings itself and indeed while he has been in detention. Your Honours have the character evidence that we put forward, and Your Honours have read that, you've said, and I won't take Your Honours through it. But the bundle of evidence that we provided demonstrates, we say quite clearly, a man who has devoted his life to the service of others. He is a man of sincerity and of duty to his wife, to his family, to the school children at his place of employment for many years, the school that he has worked at for many years, to his local community where he has lived all his life, and to his former comrades that he fought alongside at the KLA-WVA. I made submissions on Tuesday and Wednesday about his stated intention. His motive for acting was throughout to act out of that sense of duty to others. Whatever view you form of the facts, this cannot be a case, and is not a case, where it's alleged that he acted out of personal gain with a motive to further his own personal interest. He is a man of no previous convictions. That is not only relevant to the issue of whether he might offend again, but it is also something that calls for recognition, together with his character as that man of service to others, that he has reached his age without offending. He has committed no previous offence. In relation to consequences, I've made submissions on Tuesday and Wednesday about the evidence in relation to consequences. And I remind the trial panel respectfully of the burden of proof that falls on the prosecution, not only at the trial stage, as it were, but also in terms of sentencing, that the burden falls on the prosecution to prove beyond reasonable doubt any aggravating features. If they rely on consequences, then it's for the prosecution to prove beyond reasonable doubt the extent of those. And I do not repeat what I've already submitted and the evidence I've referred to on Tuesday and Wednesday about the degree or otherwise of such consequences that are claimed. But it is not controversial for me to remind the trial panel that there is no evidence in relation to, for example, the count of intimidation, that a single person has been induced to provide a false statement or to refuse to provide a statement, or that any single person has failed to provide information otherwise. There is no evidence of actual violence used or injury caused, as Mr. Pache acknowledges. And of those names that were mentioned in public, they number 14 we saw on Tuesday and Wednesday, 14 only. I do rely upon circumstances at this stage, which I say amount, in fact, to grounds for exclusion of criminal law, namely mistake of law. But if your honours were against me as to whether Article 21 of the Kosovo Criminal Code on mistake of law in fact applied or not, if you were against me on that, I would ask your honours to take that into account in terms of sentence. His clearly stated understanding of the law, if it was wrong, and if Article 21 does not apply, nevertheless reflects a lower degree of culpability on his mental state. It's an understanding of the law, understanding of the position that was reinforced by members of the press, including shared by Mr. Berisha and how he acted, other members of the press, and indeed from after the first press conference also. by Mr. Tommy Gashi, who gave legal advice to that effect also. The nature and degree of Mr. Guzzati's participation and intent in relation to any offence is still to be determined by your honours. And I say nothing in the circumstances about that, in addition to my submissions on Tuesday and Wednesday, other than, of course, the lesser the degree of participation, the lesser the intent, the lesser the culpability, and the lesser the sentence that follows. The SPO has raised abuse of power or official capacity in its final trial brief submissions. We submit that this is patently not a case where it, in fact, is alleged to be an abuse of power or official capacity case. No one's suggesting, for example, that Mr. Guzzati was properly in possession of those documents as part of his role as chairman of the WVA, not suggesting that that is access to those documents was part and parcel of his official duties or capacity, and then he abused that. This is not a case of abuse of power or official capacity. We also do rely upon the fact that he only revealed the documents themselves, or gave access to the documents themselves, to members of the press. He did not, and Mr. Haradinaj did not, take them to the street, as Mr. Haradinaj said. They did not publish them directly. They did not take those documents directly to the public. And the SPO mischaracterizes the evidence of Anna Myers to suggest that this was a case of taking documents to the nuclear option. What Miss Myers said at page 3120 of the transcript was to refer to going to the public as the nuclear option, but made a distinction over the page at T3122, where whistleblowers do not go directly to the public, but instead go to, for example, she said, non-profit civil society organizations, or the press and journalists who have duties of confidentiality that are more clearly defined and can advise and take decisions themselves about what to do, what to publish, and what not to, which is exactly what happened in this case. It is, we submit, difficult for the prosecution to characterize publication thereafter of information by the press as a serious aggravating feature, when at the same time the prosecution praises the press for the way in which they've conducted themselves. Nor is this a case properly characterized as one where victims, if that is your conclusion, victims are particularly vulnerable or defenseless. There has been no proof put forward by the prosecution that the relevant data related to victims of crime. We simply do not know the content of any communications, any information provided by anyone named in the batches has not been disclosed, and it is not being put before the trial panel. We simply do not know what information any of the persons, for example, that I refer to by letters A to L, simply because I had no other way of referring to them, meant no disrespect whatsoever. But the persons A to L, we have no idea what is the nature of the information that they had previously provided, if they had provided any to the SPO. And I say it cannot be taken as read that they provided any information, because the SPO have included in their definition of witness persons who are potential witnesses, namely persons who they think might be likely to have information. They have not restricted it only to those who have made witness statements, and certainly have not restricted it to those who are only victims, and certainly have given no evidence at all about the nature of information provided such that you could conclude beyond reasonable doubt that they were victims of crime. Indeed, of the 40 names mentioned in public, they are public names already, and in the vast majority, Serbian officials. Nor is it relevant and make victims particularly vulnerable or defenseless in this case to refer to a climate in Kosovo. All offences committed contrary to the Kosovan Criminal Code are committed in Kosovo. All offences of obstruction, intimidation, retaliation, violating the secrecy of proceedings committed in Kosovo are committed in circumstances in which whatever climate exists in Kosovo exists in Kosovo. It cannot make any person involved in this information a particularly vulnerable person, any more vulnerable than any other person in Kosovo that is subject of an offence, either of intimidation, retaliation, violating secrecy of proceedings, and so on. So, on proper analysis, not a case where victims can properly be described as particularly vulnerable or defenceless. Deterrence is, of course, a proper factor to consider, but it is not proper to impose a term of imprisonment that is longer than commensurate with the offence, simply as a device to, for example, deprive a person of the opportunity to commit further offences. That amounts not to deterrence, but to penalising future and proven offending, rather than punishing proven conduct. The sentence imposed should be commensurate with the culpability and harm committed by the offence. Imprisonment is not to be used as a device, for example, to incarcerate somebody while ongoing proceedings are taking place in other cases in order to, for example, keep one person away from the opportunity of interfering with another case. That is not a proper person, a proper purpose of punishment. Nor are Mr. Gucati and Mr. Haradinaj to be punished in any way for events that were described by Mr. Reid as occurring 10 to 15 years ago, of which Mr. Reid attributed no particular responsibility to any individual group or party or person, and certainly nothing to do with Mr. Gucati. He played no part in those historic matters, and he is not to be punished in any way for them. In relation to the term that's proposed then by the SPO, and I do not suggest on my part, although it is a matter for your honours, that your honours cannot deal with this matter by way of an appropriate sentence of imprisonment. In relation to the term proposed by the specialist prosecutor, it is calculated with no objective basis at all. It is conceded by the SPO that they do not base the calculation of that figure, for example, on any comparable case that they can find either domestically or indeed internationally. They can't because, obviously, of the cases in which they have cited, and they have cited many cases from other international courts, and acknowledging that all cases do, of course, ultimately have to be sentenced on their own facts. The canon of sentences that is set out, that is clearly defined, the range of sentences that can be appropriate for offences of this type, demonstrates that the term that's already been served by Mr. Guzzati, 18 months, whilst he has been awaiting resolution of his trial, is on any view a very significant term towards the very top of that range of sentences. And we submit it's a term which can properly be regarded as commensurate with any offence that Your Honours find proven in this case. And he can be properly regarded as being, to use the phrase, time served, when the discount that is required to be made for the time served so far is applied to any calculated sentence. Two cases I will refer to of the bundle that's been provided by the prosecution. In the case of Negira Batware, which is a recent case, 25th of June 2021, it's MICT 18116T. In that case, the main defendant, who was himself guilty and convicted of genocide, undertook a 3-year campaign, sophisticated campaign, paying thousands of euros to witnesses, which had the effect of producing both false witness statements that were submitted in evidence at an appeal stage, and indeed, as I understand it, actual oral testimony in support of those statements that was false. In that case, 2 years imprisonment was imposed for that sophisticated 3-year regime involving the payment of thousands of euros, which had the manifest effect of producing false evidence, which was submitted before the appeal court. The present proposal by the prosecution of a sentence 3 times that length, even allowing for any differences that there may be in the case, is, we would submit, excessive and indeed patently and obviously so. Before I leave that case, it is a case indeed in which the fact that the defendants had been in custody awaiting trial during the course of the context of the global pandemic and the additional hardship that in all cases, including no doubt, I'm sure the ICC maintained the same standards of detention as this institution has done. It was proper to take into account the additional hardship that was involved in that case, and we do rely on that as a mitigating feature. Your Honours will find that at paragraph 403 and 404 of Negat Batware. The other case that I'll refer to, again, we say demonstrates, frankly, the lack of sense, common sense, in the proposal that has been reached by the SPO without any objective basis. It's the case of Bemba, 17th of September 2018, ICC-01 /05-01/13, and the decision on resentencing of Mr. Bemba and others. Mr. Bemba was sentenced to a term of 1 year in relation to corruptly influencing witnesses, soliciting, inducing or assisting the false testimonies of 14 defence witnesses. So again, offences that had the manifest effect of adducing false evidence. The prosecution in that case sought terms of 5 years. And the chamber, Trial Chamber 7, rejected that proposal. 1 year was sufficient and appropriate in the circumstances of that case. But I particularly wish to direct Your Honours to paragraph 138 and footnote 225 in asserting the Chamber in that case, asserting that the prosecution had failed to appreciate the significance of a term of 1 year, commented that the term of 5 years suggested was not necessary for the case to matter, noting, as they did, this comparison. The 5-year sentence sought by the prosecution would mean the imposition of a sentence equal to or greater than that imposed on a participant in the execution of more than 1,000 prisoners. One of the persons responsible for the notorious Omarska camp, a guard at the Keterim camp, a general who facilitated the Srebrenica genocide, a general who commanded troops involved in war crimes, and a municipal official who oversaw expulsions and killings, and provided the references for each of those cases, where the prosecution in that case sought a 5-year sentence that would be equal to or greater than those imposed in those very serious cases involving genocide, the murder of 1,000 prisoners involved in notorious camps, a general commanding troops involved in war crimes, and a municipal official overseeing expulsions and killings. This prosecution seeks a sentence of 6 years. The sentencing authorities in other jurisdictions, other tribunals, do not bind, but it is behoven, this tribunal is behoven to look at where this case properly sits and to reflect, give due respect to sentencing decisions in other tribunals and courts, including in this city, and not to give a disproportionate sentence anywhere near, we would submit, the grossly disproportionate 6 years that is proposed by the specialist chambers. 6-year period well in excess of sentences that have been imposed in the city on a participant in the execution of more than 1,000 prisoners, one of the persons responsible for the Omarska camp, a guard at the Keterim camp, a general who facilitated the Srebrenica genocide, a general who commanded troops involved in war crimes, and a municipal official who oversaw expulsions and killings. The proposal from the SPO is grossly disproportionate. We say, I've submitted it already, that the 18 months is clearly within that general canon of authorities, already at the top end of such appropriate punishments, and can be properly regarded this case as one where time served is an appropriate outcome. But we say this, that if the trial panel was against us and thought that a further term was necessary, we do say that that term can be suspended. Mr. Patches referred to the provision in the law, which we say clearly makes it clear, as one would expect, that for offences committed under Article 15.2, which are Kosovan domestic offences, they ought to be punished under the Kosovan system with both the range and type of punishments available to Kosovan courts, because this is a Kosovan court trying Kosovan cases, trying offences under the Kosovan Criminal Code. And there should be no unfairness to any defendant who's tried under Article 15.2 to face a sentencing regime which is different to the sentencing regime that he would face for exactly the same offence in Kosovo. That's what we say is the purpose of Article 47. In relation to the suspension of a sentence, Mr. Pache refers to Article 47 of the 2019 Code and refers to the fact that that sets out that the purpose of a suspended sentence is to not impose a punishment for a criminal offence that is not severe when a reprimand with the threat of punishment is sufficient to prevent the perpetrator from committing a criminal offence. We say that clearly, when Mr. Gucati has already spent 18 months incarcerated, one should not underestimate the effect, both deterrent, general and specific, in that period already having been served in a country not of his own, in a different part of Europe. A suspended sentence can be imposed for any sentence up to 2 years imprisonment. That in no way suggests a punishment which is anything other than severe. No one could suggest that 2 years in prison is an insignificant punishment. So the qualifying fact has got to be, for any suspended sentence, that the offence is serious enough to merit up to 2 years imprisonment. In the circumstances of this case, that would mean that, for example, Your Honours could impose a sentence or conclude that a sentence of 3 years and 6 months was appropriate and commensurate with this offence, and the deduction then of the 18 months time served would bring the sentence down to 2 years, which could be suspended. And we would submit that that would have a real, that would address some of the concerns that in fact the specialist prosecutor raises. Because Your Honours will see that there are powers under Article 49 to impose conditions to any suspended sentence. And I don't need to go through those, but Your Honours will understand the type of conditions that could be imposed. We've in fact put conditions forward previously in relation to bail, for example. And I would ask Your Honours to consider those earlier filings. But Your Honours could, we submit, justly, proportionately, commensurately with any offence that Your Honours find proven in this case, impose a suspended sentence of 2 years with conditions that would make it very clear to Mr. Gucati, whatever his stated intention, he would know that he would have to comply with those conditions, otherwise he would immediately, without further ado, have to serve that period of imprisonment. We say that that would be a just and proportionate outcome which would meet very clearly the deterrent effect and address any risk of further offending. My submission is, in short, that Your Honours should impose the shorter sentence that is appropriate, the shorter sentence that is commensurate with the offence, unless I can insist any further.
Thank you. You have a question? Go ahead. Judge Metro.
Thank you, Judge Smith, and thank you, Mr. Rees. I will ask you the same question, and I think you've given me the answer in your submissions, to be quite frank, but I will ask you the question nevertheless. I understand you to be relying on these authorities and precedents from international and internationalized criminal jurisdictions, not as binding in any way on us. I understand you to suggest we should rely on them in the exercise of our discretion if convictions were to be entered, of course, and as guidance. Am I right in that understanding?
Yes, I don't put forward that they are binding. I do put forward that they are persuasive. I do put forward that they, of course, they ought to be afforded due respect, and they certainly should not be brushed aside, as the specialist prosecutor seeks to do, by claiming that 20 years of jurisprudence from the most senior international practitioners should be brushed aside as wrong. I concede, I accept, in fact I've put forward that there's no one specific case that is on all fours with this case. There's not. But I do say that Your Honours should look at that broad canon of cases, which does set out very clearly a general range of sentences, a general range for which the 18 months presently served is already at towards the very top limit of it. And it also makes clear that the 6 years proposed by the specialist prosecutor is frankly preposterous.
And I also noted that in some of your footnotes in your briefs, you rely on a test for cumulative conviction that is sometimes referred to as the Blockberger test that these international and internationalized jurisdictions have relied upon. Again, are you suggesting that we are bound in any way to apply that test, or is that again a submission you make in terms of us being guided by these precedent in terms of how a question of cumulative conviction, if it was a question for us to decide, would be resolved?
So can I just check which footnote in the brief that you're referring to, Your Honour, so I can see it?
67, 68, 73.
Well, I say in relation to those matters that really they only reflect the common sense, and they reflect fundamental principles of assessing culpability and their general sense and principles, which I think the court should, indeed must apply, not because necessarily Your Honours are bound by those cases from other jurisdictions, but only because they set out very neatly what are general principles of assessment of culpability in sentencing.
I'm grateful.
Judge Gaynor, anything?
Just one question, thank you, Judge Smith. I have a question about the imposition of suspended sentences under the Kosovo Criminal Code. And no doubt you've had a look at Articles 47, 48, and 49. Is it your understanding that this panel can or cannot impose, in effect, a partly suspended sentence? Which is to say, possibly impose a custodial sentence on one charge and impose a suspended sentence on a separate charge?
Not if the how the terms would operate would frustrate the suspended sentence. And what do I mean by that? Well, I suppose the answer must be no, in fact. I'm grateful to Mr. Bowden. Obviously, under Rule 1634, Your Honours are required to impose a single sentence. That's Rules 1634 of the Kosovo Specialist Chambers rules. So Your Honours are required to impose a single sentence. That would either have to be suspended or it would have to be not suspended.
So that rules out a partly suspended sentence, in your view?
If within the scope of the Kosovo Criminal Code there is the power to impose a partly suspended sentence, then it wouldn't rule it out, because you could impose the partly suspended sentence as a single sentence under the KSC rules.
Thank you. We'll take a look at it. Thank you.
Thank you, Mr. Rees. Before we break, Mr. Cadman, and we'll come back to your submission after the noon break, you filed a financial means statement for your client. Do you wish to tender this into evidence?
Yes, Your Honour. To the extent that it assists in the event that any financial penalty would be awarded, it's solely for that.
And what would the classification of the document be?
Confidential.
Confidential, all right. Any objection to that filing, Mr. Potch?
More of a few short views rather than an objection, Your Honour, if I may. On this statement, we note that the decision of the panel F572 in paragraph 19B2 ordered the Haradinaj defence to file any additional evidence by last Monday, the 14th of March. So in our view, this information is out of time. We also note that we requested what we can call a symbolic fine in our SPO final trial brief. Of course, that being said, if the panel wishes to consider this, we would not oppose that. But, Your Honours, this must be the last piece of evidence. We are at the closing stages. It's very late. I don't need to tell you that. So if this is to be considered, this must be the last of the exceptions made thus far. Thank you.
I'll take that as a no objection. Okay, all right.
Can I just say on that point, we're conscious that because there is a mandatory provision in relation to financial penalty for some offences if you returned guilty verdicts on those matters, and that you're required to consider means. We've also got a statement of means which we will provide for the trial panel to consider.
Any reason why that hasn't been filed?
It was ready at the time we filed the character statements. We should have filed it at that stage. It's an oversight that we didn't.
Well, you better get it filed then.
Your Honour.
And we'll decide later whether to admit it. Mr. Potch raises a proper objection, or he didn't object, but he raised a proper concern. We're trying to get this matter completed today.
I know, and we are too, Your Honours.
Okay.
And that statement is there to assist the court.
Okay,
because
thank you.
You're obliged to consider the financial means.
Thank you.
Your Honour, it's a very minor point, and I don't mean to be picky, but our understanding of the order that Mr. Patchy referred to was that actually the Haradinaj defence had to disclose a summary of additional evidence it would provide by Monday. On Monday, we provided evidence of witness statements, and then we said we would be providing before our sentencing remarks a submission on financial means. Just for the record, we have done that, and in our submission there would be no breach.
Thank you, Mr. Warboy. That'll be all for now. We'll be back at 2:30, and at that time we will hear submission by Mr. Cadman and any reply by the prosecution to that submission, and then we will hear from Mr. Gucati and Mr. Haradinaj. Thank you. We're adjourned.
All rise.
Please be seated. On the financial means statement of Mr. Haradinaj, the panel admits into evidence the financial statement of Mr. Haradinaj for the purpose of sentencing. This is without prejudice to the weight to be given to the statement should a conviction be entered. The classification of the statement shall be confidential, and the registry will assign exhibit numbers in due course. Now, on Mr. Gucati's financial means statement, which we received a few minutes ago, Mr. Rees, this statement is not signed, and we cannot admit an unsigned statement. Do you want to get him to sign it now?
We will address that. We will sign it today.
No, now. Yeah. So we can move on, yeah.
We'll produce hard copy.
I got a pen.
We will get a hard copy of the statement prepared so that Mr. Gucati can sign it before we finish this session.
Microphone for Mr. Rees, please.
We will, I'm just repeating it because the microphone wasn't on, we will make sure that there's a hard copy and Mr. Gucati will sign it this session.
Okay, you can sit, that's all. Mr. Cadman, you can now make your sentencing submissions. Oh, I'm sorry.
Just to clarify, Your Honor, if the question about the signature of a statement, we were just provided with two statements on behalf of Mr. Gucati. One concerns financial matters, and the other is the closing address, I believe. Was Your Honor referring to the financial one?
The financial, we're not going to admit the closing statement because he's going to make it orally.
He's going to make it orally.
Yeah.
It's there to assist we understand
I appreciate
that
the courtesy,
Mr.
but
Medill on the transcription had asked previously
Yeah.
for a copy to assist
You've
him.
seen the financial statement. Assuming it gets signed, do you have any objection other than what you noted before?
No, the same
Okay.
position as before. Thank you.
Well, we'll deal with the admission after it's back and signed. Now, Mr. Cadman. Oh, no,
Your Honor,
Mr. Rees.
Before Mr. Cadman does make his submissions in sentencing, can I just, having reflected over the lunch on the question from Judge Gaynor about part suspending sentences, we've looked again at the Kosovo Criminal Code. We can't see any provision there under the Kosovo Criminal Code for part suspended sentences. Indeed, when we look at Article 76 of the Kosovo Criminal Code, that deals with the punishment of concurrent criminal offences, that's how it's headed. The way we read that is exactly the same approach that effectively is encapsulated in Rule 163, Sub-Rule 4 of the Kosovo Specialist Chambers Rules. So we say there's actually no distinction in approach between the Kosovo Criminal Code and the rules in this Specialist Chambers for dealing with sentences imposed on the same occasion in relation to counts on the same indictment. Saying that, as a matter of effect, of course, if you were to suspend a sentence, it would in effect have it would be equivalent to a part suspended sentence in the sense that Mr. Gucati will have spent in excess of 18 months in custody awaiting trial, and then would be facing a sentence of up to 2 years suspended for an operating period of up to 5 years, with or without conditions. So it would have the same effect of a term of incarceration followed by a suspended sentence. Unless I can assist any further on that.
Anything else?
No, that's perfect. Thank you very much.
Thank you. All right, Mr. Cadman, you may make your sentencing submission.
Thank you, Your Honour. Well, let me start by saying what I will talk about and what I won't talk about. So, first of all, I won't be dealing with the matters that Mr. Rees has set out, as has been a theme throughout this case. I support and endorse the matters that Mr. Rees has spoken about in terms of the law and some of the matters that he has looked at as far as deterrent sentencing and some of the authorities that he has referred to. I will also not be using this as an opportunity to make a fourth speech, as we have heard today. But I would like to start by just referring to one matter of earlier, which was in the Specialist Prosecutor's remarks, where he stated that the evidence I refer to is not only to is relevant not only to the guilt of the accused, which has been established. I'm sure Mr. Smith knows that it is not for him to determine the guilt of the accused, it is for the trial panel. Such language, we say, is inappropriate and improper and should not be used in proceedings of this kind. It's quite plain that guilt has not been established. Mr. Haradinaj, as we know, is innocent until proven guilty. We mustn't forget that. Mr. Smith made a series of quotations using words that have come out in these proceedings. I won't go through them because we've dealt with them in our submissions over the last few days. Your Honour, we've maintained that the correct approach in this instance is that sentencing should not be dealt with at this stage. It is a matter that should be dealt with later. We are unaware of any findings of fact, and therefore it's impossible to give a full and comprehensive statement on the correct approach in this case. We therefore disagree, as we have submitted previously, that we disagree with the panel's approach in this regard. To the extent that I can address the court on sentencing, I'll say the following. But I do stress that making these submissions puts me in a very awkward position as defence counsel, where guilt has not been determined and the factual basis for guilt has not been determined. The court will be aware that the primary applicable legal framework in Article 44 and Rules 163 and 165, which in key part provide that what needs to be looked at as aggravating or mitigating circumstances or factors. In determining the appropriate sentence, the trial panel must be convinced of the existence of aggravating circumstances beyond reasonable doubt. Factors that can be taken into account are referred to in Rule 163. Prior criminal convictions for crimes under the KSC jurisdiction, abuse of power or official capacity, commission or participation where the victim is particularly vulnerable, or particular cruelty. We say that none of those factors are relevant in this case. None of those factors have been established beyond reasonable doubt. There are no previous convictions under the KSC jurisdiction. We have heard from Mr. Haradinaj in his own evidence of those matters that he suffered in being imprisoned as a minor and as a young man during the occupation of an oppressive Serbian state. But those are not matters that are relevant to establishing aggravating factors. We say that there is no evidence of targeting victims that were particularly vulnerable. There was no abuse of power, as that is designed to refer to public officials. And it has not been established that there is any particular cruelty here. So none of the aggravating factors, we say, have been proven beyond reasonable doubt. Mitigating circumstances, such as the contemporaneous and a convicted person's conduct after the act, should also be given appropriate weight. Conduct of the accused contemporaneously. First, it must be highlighted that mitigating circumstances should be dealt with on the balance of probabilities. Furthermore, in contrast to aggravating factors, that must be alleged on the indictment. We can refer to Prosecutor and Simba from the ICTR at paragraph 850. The panel should not be limited by the mitigating factors set out in the KSC legal framework. It should, as a matter of Kosovo law and international law, take into account any other factors that it deems pertinent. At risk of repeating some of the matters that have been discussed over the last couple of days, it is relevant to sentencing. The SBO have presented no evidence to suggest that Mr. Haradinaj had any involvement in the breach of SBO security, the leak of the documents. Neither did he procure the documents. He took great care to ensure that he did not publicly mention any purported confidential information. He took active steps to request that journalists were mindful of their professional obligations. These steps are demonstrable of his reluctance to put any person at risk, and neither is there any evidence that he threatened or intimidated or sought to make contact with any witness. As such, all of these matters should be taken into account in consideration of mitigating factors. At the material time and after the incidents, he was fully cooperative with SBO officers. When SBO made contact, he ensured that its officers were welcomed at the premises of the KLA WVA. Indeed, he even ensured a copy of the batches was set aside for the SBO and/or the local prosecutional police. He was fully transparent regarding the circumstances of each of the deliveries, offered all the evidence available to the SBO, including the CCTV, and in essence, he facilitated the timely investigation of this matter. He made it very clear that he wanted the circumstances of the leak to be investigated, and the SBO decided to take no action in regard to that. As we've referred to in the SDL judgment of Al-Jadid and Ms. Kayat, the cooperation of the accused after deliberate contempt can be accepted as a mitigating factor. And just to remind the court, in that case, only a financial penalty was imposed. When Mr. Haradinaj learned of Mr. Gucati's arrest, he continued his journey towards the premises of the WVA in Pristina. He made no attempt to evade justice, despite what the prosecution has sought to argue. He made his presence known and spoke with journalists and local police outside the building, as he said in his evidence. He then made everyone aware that he was scheduled to give a TV interview. And when he was arrested, requesting the involvement of local Kosovo police, he was fully cooperative. As per international practice, gravity of the offence is a primary consideration in imposing sentence. Gravity does not refer to a crime's objective gravity, rather to the particular circumstances surrounding the case and the form and degree of the accused's participation. And the assessment of gravity must be in concreto based on the particular circumstances of the case and the degree of participation, both from a quantitative and qualitative standpoint. In the contempt case of Encho Goza, it was found to be the correct approach. The trial chamber did not merely focus on the contempt as an inherently grave offence, but addressed the gravity of the particular way in which it was committed. There are several factors that need to be highlighted. No evidence has been presented to show that any individual suffered any physical harm whatsoever as a result of any action Mr. Haradinaj may have committed, depending upon Your Honour's findings. The SBO was in no way prevented from either the work of their mandate nor their ability to investigate this case or any other case. In this regard, it is submitted that any custodial sentence would be wholly disproportionate. The trial chamber must ensure adherence to the principle of proportionality, pursuant to which any punishment must be proportionate to the moral blameworthiness of the offender and must take into account other considerations. An accused's motive can also be considered a mitigating factor. Mr. Haradinaj's motives have been clear throughout. The disclosure was done in the public interest. His only intention was to bring attention to what he considers to be the SPO's inappropriate and unethical collaboration with Serbian officials, who he considers, and much of the Kosovo public considers, to have been involved in the perpetration of massacres of hundreds of Albanian civilians during the conflict. It cannot be said, despite what the Special Prosecutor has said, that he was motivated by personal gain, but rather was done in pursuance to his commitment to bring all perpetrators to justice, as he has repeatedly set out during these proceedings. We refer to Rule 163, paragraph 4, the principle of totality, in our written submissions, and I do not intend to go through that in any detail here and now. But looking at the sentencing for each of the counts, we look at counts 1 and 2. In our submission, considering that Mr. Haradinaj never directly threatened or indeed contacted any of the witnesses or public officials, then the only appropriate sentence, if Your Honours return a verdict of guilt, would be as short a period of imprisonment as possible. And you'll be mindful of the time that Mr. Haradinaj has already spent in detention. In our submission, Mr. Haradinaj's actions did not prevent nor preclude the SBO officials from undertaking any activity within their mandate. Nonetheless, if the trial panel is minded delivering a custodial sentence on these counts, which in our submission is not justified, any such custodial sentence should be within the lowest range of what is available. And in our submission, it should only be no more than time already served. Regarding count 3, there is no evidence, certainly no evidence presented during these proceedings, of any SPO witness or any other person being the victim of direct intimidation, nor did Mr. Haradinaj engage with any offers or communications with any witnesses, protected or otherwise. As a result, it is the defence position, on behalf of Mr. Haradinaj, that any sentence for this count should remain non-custodial. Addressing count 4, given the lack of evidence of retaliation directly or indirectly implicating Mr. Haradinaj, it is our submission no custodial sentence is warranted. But once again, if the trial panel is minded that a custodial sentence is necessary, it should be as short as possible and should be no more than time already served. Count 5, given Mr. Haradinaj's motivations, which were always in the public interest, we submit that a fine would be the just and appropriate sentence if a verdict of guilt is returned, to reflect the conduct and the gravity of that offence. And turning to count 6, Mr. Haradinaj took active steps to not reveal any confidential information, and therefore does not fall foul of Article 392, paragraph 2, which requires the imposition of a custodial sentence of up to 3 years. Nor does he fall foul of Section 3, as it cannot be stated that there were serious consequences for those under protected status whose names were leaked. Again, as a result, a custodial sentence is not warranted, but again, should the panel consider that it is, it should be at the lower range and again should be no more than time already served. When dealing with practice amongst the international ad hoc tribunals and sentencing policy, I adopt the same position as Mr. Rees has set out, as requested in questioning by His Honour Judge Metro, and say that these are matters that the trial panel is entitled to take into account when considering where this case sits as far as sentencing policy is concerned. We refer to Mariacic and Rebic, journalists who disclosed protected witness information in violation of 3 court orders, who received a fine of 15,000 euros. Similarly, in Josip Jovic, journalists who published protected witness information refused to comply with the court order. He was fined 20,000 euros. We also refer to the matters before the Special Tribunal for Lebanon, in which journalists published confidential information on protected witness despite orders to cease, desist, and remove the information. They were fined 10,000 euros and 20,000 euros respectively in the 2 matters that we cite in our earlier filing. It is our submission, considering these authorities, and it is accepted that all matters have to be determined on the individual facts of that particular case. It provides the trial panel with some guidance as to what would be the appropriate sentence. Despite all the preceding submissions, should the trial panel consider that notwithstanding the mitigating circumstances advance, proportionality and the totality principle, a custodial sentence is still warranted, once again we submit Mr. Haradinaj having served 18 months in custody. These matters should be taken into account. I'd like to deal now with some broader personal mitigation that relates to Mr. Haradinaj. We know that his personal circumstances have changed significantly during his detention. 4 months after the shock of his arrest, his wife was diagnosed with stage 3 cancer. She had to undergo chemotherapy, and she had to have surgery, followed by a period of radiotherapy. His wife was isolated during one of the most difficult chapters in her life. His absence from family life has been particularly felt during these exceptionally challenging times for his wife and the entire family. And even though she is now in remission, the treatment that she has received has taken a significant toll on her body and her mental well-being. As both a husband and a father, Mr. Haradinaj is understandably concerned about the very real possibility that the cancer could come back. And like any husband or father in such circumstances, it is agonizingly difficult for him not to be with his family during this time. A custodial sentence, a further custodial sentence, would have a devastating consequence for his wife's health and his family's well-being going forward. I implore the trial panel to take this matter into account. But this situation is further exacerbated by the ill health of his younger brother. I won't go into details, but as you'll see from the character reference from his son, he has stated that the health is deteriorating every day. And we have seen for ourselves the toll that this has taken on Mr. Haradinaj during his testimony You'll recall when speaking about his brother, he was hardly able to hold back tears as to how this has affected him and his well-being. Cumulatively, these personal circumstances clearly amount to exceptional in nature, and the trial panel cannot be blind to these when considering mitigation as recognized by previous international courts. Your Honours have the character references on behalf of Mr. Haradinaj, in addition to his wife and son. You also have, and I'm mindful of the redactions that need to be made to the statement of Ambassador William Walker. But you will see two incidents in which Ambassador Walker interacted with Mr. Haradinaj. These incidents show a clear sense of duty to reach a non-violent approach to resolving a dispute, and it shows very clearly that Mr. Haradinaj is a man who puts others before himself. Today we filed a statement of financial means. I will not go through that financial statement in open session. Your Honours, we've adduced this statement to be transparent and to show that if a financial penalty is imposed, what Mr. Haradinaj would be in a position to pay. A fine of €20,000, like other tribunals have imposed, is significant and a deterrent contrary to what the Specialist Prosecutor has said. To many of us in this courtroom, a financial penalty of €20,000 may not seem an exorbitant amount of money, but in Kosovo it is, and to Mr. Haradinaj it is. And so we urge you to take the reality of the situation and the context into account, especially as you are ultimately an institution of that country. Finally, on remorse. As to remorse, we say this is a misplaced argument by the Specialist Prosecutor. As you saw in the video that the SPO played, Mr. Haradinaj has considered at all times that he was acting transparently and in the public interest. If ultimately it turns out that you consider that to be unlawful, which we say it was not, then imposing too much of a penalty may well have a broader negative, detrimental impact on free speech. My submission is that over-punishing for any crimes that may have an unintentional chilling effect on the people in the Republic of Kosovo should be avoided. And that is, in essence, a further instance of oppression for an oppressed people. I ask you to take all these matters in account, as I'm sure you will, in making a determination of what will be the most appropriate sentence. We submit that his actions would deem a non-custodial sentence as just and appropriate, a financial penalty within his means, and once again, if the panel is minded to deliver a custodial sentence, given the totality and proportionality, in addition to his exceptional personal circumstances, any custodial sentence should be as short as possible, especially considering the near 18 months that he has already been detained. He has, de facto, already served a significant proportion of any custodial sentence that could be imposed upon him, and he should therefore be released at the conclusion of these proceedings and returned to his family as soon as possible. Your Honours, thank you.
Thank you, Mr. Cadden. Mr. Rees, do we have a signed statement at this time?
I believe we do. We have it here. We can either provide it to the court now, or we can make sure that it is disclosed via
The
legal
usher will
workflow.
take it from you. It should be filed electronically as well, though. And the panel admits into evidence a signed version of the financial statement of Mr. Gucati
I'm grateful, thank you, Your Honor.
for the purpose of sentencing. This is without prejudice to the weight to be given to this statement, should a conviction be entered. What classification do you want the statement to have?
Confidential, please. It relates to his private financial
Thank you.
circumstances.
The registry will assign exhibit numbers in due course. Any questions of Mr. Cadman from the panel? No? Does SBO wish to respond to the sentencing submissions?
Very briefly, if I may, Your Honor, it's a matter of minutes.
Yes.
Thank you. I'll start by addressing the submissions made in passing by counsel for Mr. Haradinaj about the appropriateness of making submissions on sentencing at this stage. And all I want to say in that regard is that this matter has been addressed and decided on. The parties have been on notice of this, both from the court's regulatory framework and from the decisions by the panel. The parties have been given equal opportunities and have taken advantage of those opportunities to make the relevant submissions. Turning to the specific cases from other courts cited by the defense, I've already addressed those cases addressed by the Haradinaj defense. I will address the two cases counsel for Mr. Gucati mentioned, and those are the ICC's Bemba et al. Case and the MECT's Inzabonimpa et al., which includes Mr. Ngibra Batware, mentioned by counsel. And these two cases, Your Honor, they truly serve to provide additional evidence, not that we submit any was needed, as to why other cases need not be considered in relation to the sentence to be imposed on the accused in this case. The case in which Mr. Ngibra Batware was a co-accused concerned alleged interference through bribes to 9 individuals. The Bemba et al. Case concerned 14 witnesses. The count of unauthorized disclosure Mr. Ngibra Batware was convicted of concerned disclosure to his co-accused, not to the media, not on television. Further, Your Honors, generally, bribe cases differ from those which involve threats and intimidation. Bribing 5 witnesses, for example, does not generally pose a risk to other witnesses in the same way that intimidation and naming in the public sphere can have a risk on other individuals, such as the circumstances in this case. And here again, I refer to the evidence you heard on this note by the defense's own expert, Mr. Reed, that both myself and the specialist prosecutor referred to earlier today. The last thing I will say is that neither of these two cases that Mr. Gucati's counsel raised made any findings of threats. In fact, I will just read from paragraph 398 of the Nzabonimpa trial judgment. And there, the single judge stated, and I quote, "I am mindful that it was not established that the accused employed threats, pressure, or intimidation to secure cooperation, and that the witnesses in some cases seemed all too willing to exploit Ngibra Batware's need of their participation in the review hearing to present ever-increasing demands for money in exchange for their cooperation." End quote. And Your Honors, unless you have any other questions, those are our submissions.
Thank you, Mr. Podge. At this time, we're going to hear the statements of the accused, Mr. Gucati and Mr. Haradinaj. Each of you have 30 minutes at your disposal. You are not required to use the 30 minutes, but when we have finished with Mr. Gucati's statement, we will go directly for Mr. Haradinaj's statement. The statements should focus on and be limited to matters that are relevant to these proceedings. I also ask the accused to speak at a slow pace so the interpreters can translate their statements. Mr. Gucati and then Mr. Haradinaj, You may feel free to sit while you make your statement or stand, whichever is most comfortable for you. Or if you wish, Mr. Gucati, if you need to stand up during it at some time, that's all right as well. Mr. Gucati, the floor is yours.
Faleminderit.
Thank you.
Just start.
Greetings, dear Your Honors, judges. I wish to also thank Mr. Nayeta Sani, Ambassador of Kosovo here, and I also wish to greet Ilka Getzi and all the other participants in this proceeding. I want to tell you that I'm a very proud citizen of the Republic of Kosovo. I am very proud of where we are today as a nation, and I'm full of hope of what can become in the future. I will continue to fight for the rights of my people up until my dying day. It is the future of all the people of Kosovo that motivates me to do so, and to do what I believe will help this. In 1997, I and many peers of mine joined the Kosovo Liberation Army. I did so to defend my homeland and to protect all the people of the Republic of Kosovo. In the course of serving my country, I was severely injured. I witnessed many terrible things during this time. I witnessed war. These are things that I would never wish to see again, or would never wish to see repeated in any country of the world. Any victim of crime during war or a victim of crime during peace deserves the right to have those persons who have committed the crime against them to be investigated against and to be prosecuted. I was, of course, the victim of such a crime myself, as were many of my fellow members of the Kosovo Liberation Army and many citizens of Kosovo. And those crimes should have been prosecuted where possible. Therefore, as a victim of crime myself, I do understand what other victims of crime have suffered, and I sympathize with the pain that they have suffered, and I would defend their right to justice. It can, however, be right to declare a group responsible for criminal acts when the very establishment of that group was to stop rather than commit criminal acts. When I joined the Kosovo Liberation Army, my only intention was to defend my fellow citizens and to avoid any suffering that might be inflicted upon them. I would be greatly offended and astonished if my time at war from 1997 can be looked as something else rather than a right and proper act on my behalf and on behalf of all the other members of the Kosovo Liberation Army. To do anything other than that, what I did in joining the KLA, would not have been fulfilling my sense of duty to the people of Kosovo. The right of the people of Kosovo and the rights of the people of any nation should be that at all times they are able to live in peace, to feel able to express their thoughts through free speech, to live without fear, and for those who do not act in such a way to be prosecuted. These rights should be respected and ensured at all the times and all over the world. I will always stand with anyone who looks to protect these values. I became the chairman of the KLA-WVA to ensure these rights for the members of the KLA-WVA. I always acted in their best interest and to secure a safe and secure future for them and for their families.
This involved me pursuing their cases with various people to include the political establishment of Kosovo and beyond, if so required. At all times, I acted for the KLA-WVA members without fear or favor. If I thought that something was said, if something was done or established that acted against their best interest, as I saw it, it was my duty to protect and serve them. I fully accept that in acting in the best interests of the members, this included expressing the view of the members of the KLA-WVA regarding the establishment of the Kosovo Specialist Chambers. It was my duty to do so, namely to protect them. In September 2020, I was faced with a decision as a chairman. I had to take that decision as the chairman of the WVA upon the totally unexpected arrival of the documents at our offices. I made the decision with the steering council of the KLA-WVA. This decision, as far as I am concerned, was in the best interests of the members of the KLA-WVA. On the 25th of September 2020, my life changed, and the life of my family changed as well. I have never looked to hide away from the decisions that were made in September 2020. I did face the consequences of my arrest in 25th September 2020. I faced the consequences, and I also respected the same sense of duty that has always been with me. As my counsel has so clearly explained to the court, I maintain that I'm innocent of any criminal charges against me. I acted, as I have done throughout my life, out of sense of duty to others. For the past 25 years, in my role as a member of the KLA and as a member of the KLA-WVA, I have always tried to act out of that sense of duty and responsibility to the membership of the KLA-WVA and to my country. I'm very proud to be a citizen of the Republic of Kosovo, and I'm very proud to be Albanian. The Kosovan nation has never been in any aggressive position against any other country. We must have the right to defend ourselves against those who challenge our right to live in peace. All nations must have the right to defend themselves against an aggressor. I am proud of all my comrades of the KLA-WVA, and I will forever act in their best interests. By way of concluding, allow me to say a couple of words as well. I wish to say that any suggestion that has been made on behalf of the KLA being a criminal organization is utterly untrue and absurd. It is an insult to the martyrs and the fallen who died for the Kosovo state. The KLA was, is, and will always continue to be a symbol for freedom and democracy of the people of Kosovo. Thank you very much for your attention.
Sati. Mr. Haradinaj, the floor is yours. Remember to speak slowly for the interpreters to catch up. And as I said earlier, you may stand or sit, whichever you wish.
Thank you, Your Honor. Honorable judges, and my country, my family, who appear to continue to be persecuted. When the session of the 14th of March started, and I heard that I was going to give the chance to speak for another 30 minutes, I never thought that there would be a need for me to speak, regardless of a decision on conviction or not. I had decided not to speak up at all, but hear the end of the judicial process. However, when Prosecutor Valeria Borici took up the floor, she started to unashamedly impose a fait accompli before the trial chamber. She made an amateur legal mistake within the judicial proceedings, something that is not supposed to happen even in dictatorial societies, but she insulted us unashamedly and tried to put us and the trial chamber before fait accompli when she said, and I cite, "These two are criminals." Given that the trial chamber did not react to that, that prompted me to take up the floor. And let me reiterate that this is an unprecedented, this is a surrogate prosecutor's office. I understand Prosecutor Borici because I understand that she's angry that she is not in possession of facts to be able to come to a conclusion that she wants, but she needs to be aware that even to this point we need to be considered innocent until proven guilty. We have never cooperated with criminals or carried out their orders. We have never taken any advice from criminals either. The fact that you do not disclose the location of those criminals to Interpol and to international justice, to Interpol, and they are on their red notices, that makes me and many citizens in Kosovo to guess who are you going to prosecute, who you are identifying with. The Special Prosecutor's Office said that we have been obstructing justice for 20 years on end. If that were the true, Prosecutor Borici ought to... he's forgetting that this chamber was formed only 7 years ago. It is an amateur mistake, Mrs. Prosecutor, because the indictment charges us with a number of crimes carried out over a couple of weeks. If, however, she has in mind the time during which I defended the rights and freedoms of my country, she is wrong again. Because since 1978, when I was 15 years of age, for 44 years on end, that is, I have fought for the freedom and the legitimate rights of my country, and I have done my utmost to fight against the slavery of my country and for its occupation, and I will continue to do so to the end. I have said twice before the trial chamber here that I'm innocent. I shall do the same today, but let me say, in the end, because that might help the prosecutor to in a way, understand why she insulted me given from the podium that she's been given. If I want I am for the human rights of my country, and I remain committed to fight against the slavery of my own country. If that issue is a crime, then you have problems with countries like mine and with yourself too. This Chambers is here to seek justice, and my opposition is with the prosecutor's office. It's an office which is not carrying out its tasks vis-à-vis the people of Kosovo. So, honourable trial chamber, I expect impartial justice on your part, uninfluenced by anyone. I want nothing but justice to triumph. I do not seek anything else apart from impartial justice. Whilst to you, Prosecutor Borici, you need to pull back, to withdraw the term criminal, because it does not attach to me, it does not belong to me. I should have been able to complete my speech by now, but given that the Special Prosecutor is here, and in order for him not to feel insulted that I have not noticing him, however, it's not that I did not pay attention to his words. Mr. Smith said two things. One, in personal interest. He said that Mr. Haradinaj has a personal stake, a personal interest in this. Everybody knows me, and you know that this is a lie. It's nothing to do with the truth. If I had been seeking personal gain, I would have stayed with my family. I wouldn't have gone and joined the war. I wouldn't have been imprisoned. You, in a way, are trying to seek to influence this trial chamber. On the second issue is that you wanted the most severe punishment for me, so the others would be deterred. Mr. Prosecutor, listen, Mr. Prosecutor, you're going against yourself. If you remember your first speech, you said it is allowed to think differently. Your views, Mr. Prosecutor, our views of dictatorial prosecution's office it's like the Yugoslav system in 1981, the time when we were not thought to think differently. You should be ashamed. It's an insult on yourself, on the quarter of a century of experience, and on the country you come from. And Mr. Patch, so he doesn't feel excluded. Mr. Patch said something that I understand came from the depth of his soul, even though he tried to hide it. He said, and turned to the witness, a lot of massacres, crimes, and killings have occurred in Kosovo. And in that country, the witnesses who goes against these heroes are thought of as traitors. Yes, that is what my country thinks of. Everybody thinks of. That's what people in Sweden think. And I'm a Swedish citizen too. Mr. Patch, if that were true, I mean, you ought to be charged with crimes because you imparted an intimidating message towards witnesses, because if you think that those who come here to witness against national heroes are traitors, it means that you want to charge those heroes as the guilty party. Let me reiterate, I have done everything with full transparency and in the full interest of the public in Kosovo. Thank you very much for allowing me to take up the floor and for listening to me.
Before we continue, the panel will render an oral order on the procedure to be followed regarding sentencing should a conviction be entered. The panel took into consideration all relevant factors and the evidence that has been tendered and admitted. The panel also considers that both parties were in a position to make full and effective submissions on sentencing and to rely on the evidence they tendered for that purpose. The panel accordingly sees no need to entertain the possibility offered by the rules to have a bifurcated sentencing process in case either or both of the accused were to be found guilty of any of the offenses with which they are charged. For these reasons, the panel, pursuant to Rule 159, Paragraph 6, will determine an appropriate sentence with the pronouncement of the trial judgment should any conviction be entered. This concludes the oral order. Do the parties wish to raise any further matters, any questions, any concerns?
Only in relation to perhaps planning, looking ahead, travel arrangements, and professional diaries. Does the trial panel at this stage have any idea as to when pronouncement of judgment may take place?
Not so much that you could count on it. We will be sure and notify you as soon as we can start getting some sort of an idea. It will be in advance so that you don't have to, change schedules.
I'm very grateful.
We'll try to communicate with everybody at the same time by email, get some information back from you, and then set a date.
Thank you, Your Honor.
Thank you. Anything from you, Mr. Cadman? Anything further from the prosecution? The panel will, in due course, request submissions on reclassification of transcripts. And of course, the detention review also continues. Other than that, pursuant to Rule 135, No further submissions or evidence may be made to the panel unless in exceptional circumstances and on showing of good cause. The panel wants to thank all counsel and those who assisted them for their individual and collective contribution to this case. We felt greatly assisted by your contributions in ensuring that proceedings were fair and that the defense of both accused was effective at all times. The panel also thanks the Court Management Unit for their excellent work and for the 24/7 availability throughout the case. The panel is also grateful to the court reporter, the interpreters, and all involved in the registry for their assistance. As I said, the panel will be in touch with the parties in due course regarding the date of the judgment. This case is closed, and we are adjourned. Yes,
I do apologise for making, after you've closed the proceedings, but as I do apologise for raising an issue after closing the proceedings, but you have mentioned the question of detention. I appreciate this is not a matter that is within the trial panel's control. We have 2 appeals pending for some time now before the Court of Appeal on detention. We really don't know when a decision is going to be reached. Again, I appreciate it's outside of your control, but if there's anything that can be done to speed up this process, because you're going to have to consider detention again, and we just don't know when a decision is going to be made on the 2 appeals.
I will make inquiry, and hopefully that I'll get some good news. Thank you.
All rise.